just before we start, could I just say a couple of things? First, it's the 4th anniversary of Hurricane Irma. Of course, I cannot fully appreciate, I cannot fully imagine the effects of that hurricane. Only those who are here, who endured it and its immediate aftermath, could possibly do that. But we have seen and heard a considerable amount of evidence about the devastation it caused, not only to the physical geography of the country, but also to the welfare of those who live here. I am very sensitive to that, and also to the reaction of those who live in these islands to Irma, and later to Maria, and later still to the COVID-19 pandemic. They have met these natural disasters with great fortitude and great resilience. And today of all days, that is very much at the forefront of my mind, and I know in the minds of all my team. Second, today we resume taking evidence at COI hearings. I'm afraid that this morning we will have to deal with some of my frustrations in making progress. The causes today are very much the same as the causes in June and July, when they were fully aired in the open hearings that I held. I will continue to press for information which I consider relevant to my terms of reference. However, I should make it quite clear that I've reached the stage of this inquiry when it is more than ever important that I press ahead, complete the hearings, and write and promptly deliver my report. I have no doubt at all, that the public welfare of the BVI requires that I do. I'm afraid that I, and indeed my whole team, have been frustrated, but I must make very clear that nothing and no one will deflect or distract us from completing the task set by my terms of reference. Thank you very much. Mr. Rawat.
Good morning, Commissioner. Can I, before I make any submissions, just introduce the representation that we have? In line with COVID restrictions, you have issued a direction that effectively limits the numbers who can be in the hearing room to those that need to be here. And in terms of legal representation and witnesses, the focus is on allowing or creating circumstances in which a witness can safely attend in person. And that means that those legal representatives who are not representing the interests of that witness will attend remotely. And in terms of those who do, they will be limited to one person. Today, the one witness we have is not legally represented, and so quite sensibly, other legal representatives for other participants are attending remotely. And if I could just introduce the individuals that we have online. We have Mr. Hussein Hyri, Ms. Sarah Jane Knock, and Ms. Lauren Peaty, all of whom are here on behalf of the Attorney General and the elected ministers.
Yes.
The other participants, as you will recall, are remaining members of the House of Assembly, represented by Silk Legal. They are not attending and have not contacted the Secretary to make any arrangements to attend, even remotely. The first matter on the hearing schedule today has been listed as a directions hearing. And if perhaps I could just explain the purpose of that. It follows on from the remarks that you made a few moments ago, Commissioner, and that is to understand the present position in relation to a number of specific issues. They are, firstly, compliance with requests for affidavits in relation to statutory boards and the redactions that may be sought in relation to material that may be used at a hearing concerning statutory boards. That is perhaps the most pressing because as you in the public were informed in a press notice, statutory boards is in fact the first topic that we intend to canvass in these resumed hearings. The second topic I would welcome assistance on is clarification of the Attorney General's position in relation to the redaction of the response that the elected ministers submitted to the Governor's position statement. The third is clarification as to the position of the Attorney General in relation to disclosure of documents relating to belongership. The fourth is progress in general on affidavits. And the fifth is an issue that we canvassed in July, but you may need in light of recent correspondence to return to. And that is the position of participants as to the meaning of the paragraph 1 of the terms of reference.
Yes, the scope of paragraph 1. Yeah.
The terms of that. So what I propose to do, Commissioner, with your leave, is to take each of these topics in turn, but then pause at the end of each one so that you can then invite submissions if required from others. Yes, thank you very much. So the first topic is statutory boards. What I would emphasise today is that what we would hope as the COI team is that the product of this hearing is not to go at length or in any granular detail about events of the past, however recent, but rather to kind of come to a pragmatic solution as to the way forward. That is particularly important in this case because otherwise we will not be able to do the hearings that we so want to do. But I do need to give this some context. Now, and some history. On the 2nd of June, you publicly announced those topics that you intended to investigate at further hearings, and they included statutory boards. Requests for affidavits were sent out on the 4th of June, and in your remarks 2 days earlier, you indicated that the reason for asking affidavits was so that you could they would result in more focused hearings. Progress, and this has been ventilated at previous hearings, has been slow, not just in relation to affidavits relating to stat boards, but in relation to other affidavits. And you have had to grant extensions. And as we have made clear again in previous hearings, with very, very limited exceptions, you have granted those extensions in the hope that it would produce useful evidence that would mean more focused hearings. But the delays in relation to statutory boards and the production affidavits were such that you could not, as you intended, deal with the topic in the week commencing the 19th of July. The expectation, however, was that we would receive outstanding affidavits well before the resumption of hearings, but unfortunately that has not happened. And to give some immediate examples, one of those who's been asked to make an affidavit is the current Financial Secretary, Mr. Jeremiah Frett. An affidavit was received relating to statutory boards was received from Mr. Frett on the evening of the 3rd of September 2021, notwithstanding that it had actually been sworn on the 26th of August 2021. Affidavits were received from Tasha Bertley and Carolyn O'Neill Morton, both permanent secretaries, late last night. Those documents run to hundreds of pages, and both these witnesses are due to be called this week. As we have said before, the concern of the COI is that when there are such delays, it undermines the ability of the COI team to prepare properly, and it puts at risk the hearing timetable. And that doesn't just disrupt the COI, it disrupts witnesses who will have taken time and been scheduled to attend on particular days. But as you have indicated, Commissioner, that we have reached the point where delays of this sort cannot be allowed to continue to disrupt the course of the COI. As well as delay, a parallel issue has been redaction. And it may assist if I just set out in summary the approach that the COI has adopted when making requests for affidavits. When letters of request have gone out seeking an affidavit from government, they have always been addressed to the ministers. The recipients of those letters of requests and the letters of request set out specific questions and issues to be dealt with and ask that all relevant documents be exhibited that address those questions. But in the letter, recipients are asked at that point to identify any redactions on any ground. So that includes, for example, legal professional privilege or public interest immunity. And to then provide redacted versions of any documents in two forms. The first is with the redaction sought blanked out completely, so it's not visible, and the second with it shaded so it remains visible. Now, our protocols allow that. The provision of the redaction protocol that is on the inquiry's website, paragraph 14, envisages that. And the same point, perhaps more importantly, is made in the protocol on the provision of written evidence. Now, we make that request in every letter for good reason. And that was because it minimizes delay. And it was prompted by the fact that in earlier hearings, when we first started our hearings, which were in private, what emerged was that there was not that disclosure was in disarray, but it was missing. And that in part prompted the request for affidavits. I say in part because it is conventional in any inquiry for that inquiry, first of all, to seek general disclosure. And then as it goes through that disclosure to make requests, sometimes for witness statements, but in this jurisdiction, it's the affidavit. And what those requests are intended to do is to ask a witness to explain a particular issue. In our case, the benefit was that where we had experienced delay in getting documents, etc., having someone explain circumstances and exhibit relevant documents was intended and should have reduced delay. Because the consequence is that if you as Commissioner agree with a proposed redaction, then that document can be used in redacted form. If you don't agree, or if there's an issue that has yet to be resolved, then the shaded version can be used. And that then allows all those involved and with access to the document to understand that there may be some parts of a document that are subject to sensitivity or may be the subject of an application. And it's a pragmatic way of allowing a hearing to proceed. The important point perhaps to remember is that when we are using documents at a hearing, we are not automatically releasing those documents to the public. They are not, for example, published on the website. And so it's a different situation from one where an inquiry were to immediately publish all its information onto its website. And in my experience, that is not what inquiries do anyway. But regrettably, across a range of requests, and I'm not here speaking specifically of statutory boards, the position of the Attorney General has been and can properly be described as a marked reluctance to comply with a direction in a letter of request to identify those matters on which she seeks redactions. You may be asked, or the issue of personal data may be raised in any submissions that are made to you on this point. But in my submission, that's a distraction, because one can work around a document that contains personal data. There would be limited circumstances in my submission where one needs to refer, for example, to a telephone number or an email address. And we have the protection of the fact that we are not publishing on our website straight away. More importantly, is that the Attorney General's stance has been to say that in relation to material that she provides to the inquiry, she maintains or reserves a right to make a claim for legal professional privilege or a claim for public interest immunity, or indeed for another sort of confidentiality or privilege. Now, that in my submission is not enough, because it begs the question, well, what are you making the claim in relation of? And it is the Attorney General that is best placed to identify the basis of it. And it is important that that was done early enough, because if we take the example of PII, or public interest immunity, it is not enough for a participant to say, I raise public interest immunity in relation to all the documents I have provided to you, or a set of documents that are exhibited to an affidavit. And the reason for that is because just simply saying the words public interest immunity out loud does not prevent a commissioner from using that material. There is an application that has to be made. The basis of the immunity claimed has to be identified. It has to be developed as an argument. And ultimately, you have to be persuaded that the balance between public interest immunity, which means that the document or documents are not used at all, outweighs the interest in having an open and transparent inquiry, which is, as I understand it, and as the COI has always understood it, the wish of all participants involved in this process. So if I return back to statutory boards and the problem we face, which is a practical one, and I hope that with the assistance of participants, we can come to a solution. On the 24th of August, the Attorney General was provided with a hearing bundle and asked to confirm whether there were any redactions to be sought on whatever basis. At that time, the COI was still, in fact, awaiting affidavits on statutory boards. The Attorney General was also asked to confirm if she had any objection to Silk Legal having a copy of that same hearing bundle, which was unredacted. We keep in mind, of course, that Silk Legal owe you the same obligation of confidentiality that everyone else does. The attorney was asked to provide her response by the 27th of August. An extension was requested and granted to the 30th of August, but it was not possible for a response by that date. What we did receive on Saturday, the 4th of September, was a redacted bundle. And the following day, that is yesterday, the attorney indicated that she was content for that bundle to go to Silk Legal. Now, in the context of both delay and the provision of redaction, it may be said, and reference may be made, as it has been made, to the fact that public officers are overstretched and have worked extensively to provide assistance to this inquiry. That is a good point. And you, Commissioner, have on more than one occasion expressed your thanks to those officers in the civil service who have made considerable efforts to provide the COI with material. It is a point that is stronger on delay, perhaps, than it is on redaction, because if the attorney wishes to make an application for redaction on the basis, or assert legal professional privilege, or make an application on the basis of public interest immunity, that is a matter for her, not, for example, for a public officer to really determine. And rightly, one can also, as was done in July, point to the circumstances of the pandemic that have affected the BVI. But what we must also bear in mind is that those very factors were taken into account when granting extensions. That the letters requesting affidavits, and this is the stage we're at now, was addressed to ministers. And it was ministers that decided to delegate the making of affidavits to public officers. That those officers, we assume, have the same support from the IRU, which is well-resourced and has a significant number of lawyers working for it. The same support will go to those public officers as would go to an elected minister making an affidavit. And that in many cases, these affidavits were requested months ago. The situation we have reached is, and can properly be said to be, an unhappy one. We have had, as a COI team, to prepare for statutory boards on the basis of our own hearing bundle. And so we're in a position where we now have two bundles, and we need to find a pragmatic way forward. The history I have set out is not intended to repeat criticisms that may have been made of legal representatives and participants in the past, but it is to give context to the proposal that I want to make and put to you. And that is that I suggest that we use the hearing bundle that has been prepared by the COI. And I say that for the following reasons. Firstly, the point that I've already made, that there's a difference between referring to material at a hearing and publishing it more widely. Secondly, that if there is a concern that, for example, a cabinet paper that has been provided to the Commissioner and is in that hearing bundle contains reference to material that does not relate to statutory boards and therefore should be redacted, well, that concern doesn't really arise, because I cannot think or envisage the circumstances in which, when we are dealing with the topic of statutory boards, we will need to refer to any other part of a cabinet paper that refers to another topic other than statutory boards. That is our focus. Thirdly, if there is a concern over personal data, then we will, as we have done throughout our hearings, take care when referring to it. The issue in relation to personal data that has arisen is in relation to the fact that CVs or resumes of persons appointed to statutory boards has been provided to the Commission. Those CVs are in the hearing bundle. Whether they become relevant may depend to a great extent on what witnesses say. Our understanding is that the Attorney General does not propose, or the elected ministers do not propose, to rely on the CVs at present. So she has, to some extent, on their behalf, the Attorney General has reserved her position. And so there is recognition, and there was further recognition of that there may be personal information that is relevant on the 13th of July, when Mr. Olympitis was representing the Attorney General. I may have got the date wrong. It's the date on which Order 19 was made. And so that, in my submission, is something that we have to deal with on a case-by-case basis as the evidence emerges. But the last point to make is that what we have, the additional protection, is that is of the 3-minute delay. The effect is that we are not broadcasting immediately live, and that delay would allow a witness or a legal participant to raise a concern, which you would then take into a private session and determine before we resumed our public hearing. As to Silk Legal, they are not represented here today. It is not entirely clear whether they intend to appear in relation to the Statutory Board's hearings. They don't represent any of the witnesses who are going to be called. The COI rules do allow you to decide whether a court participant should have disclosure of a particular document, and if so, in what form. And the pragmatic solution that I would proffer is that in the first instance, whilst within the hearing, we are using the COI's hearing bundle, that the redacted bundle be provided to Silk Legal. If there are additional, and there has been additional material that the Attorney General has provided, and I've referred to the 3 affidavits that came in late, then she can propose redactions to those, and those can then be passed on to Silk Legal.
Are the pagination numbers in the redacted bundle the same as in the hearing bundle that we have prepared?
Yes.
Good. Okay. So, so in practice, that should work.
Yes, it would allow Silk Legal to understand the issues and to follow proceedings.
Yes.
It would be a matter for them if they wish to make any applications in relation to the bundle they have been provided. But it seems to us, as the COI team, that the approach I've outlined and the proposition I've put is a sensible way of ensuring that we can progress and call witnesses in relation to statutory boards.
And as you said, Mr. Rowd, Silk Legal, who aren't here, could make an application. I'm not quite sure what the base of it would be, but they could make an application to see the full bundle. They're covered by the same confidentiality as anybody else, but they may not think that's necessary.
And if they do make an application, that would give the Attorney General's
exactly
an opportunity to explain why she objects or whether she no longer maintains her objection.
Yes.
I'm going to pause there because it might be a sensible point at which to invite a response from or observations from one of the three legal representatives to the Attorney General.
Yes, I think the correspondent suggests it's going to be you, Mr. Hire. Is it going to be you?
Yes, Commissioner, it is going to be me.
Good, okay. I mean, without wishing to stop you saying anything you want to say, given that we are starting the oral hearings on statutory boards today, now, I'm most anxious to find, under this head that Mr. Rawat has opened, a pragmatic solution to the issues that he has raised. I have to say, I think a pragmatic solution should be readily achievable.
Thank you, Commissioner. So I think, if I may, there were a number of background points that Mr. Rawat had made, and I don't propose to address them all, but I think it might be helpful if I set out a little bit of background and context on at least some of them. I think he started by addressing the issue of the affidavits and the question of capacity, the question of difficulties in this period of COVID, the question of resourcing. And I think that there are important points there which are very pertinent, because since the 20th of May, we've had not less than 59 affidavit requests, which is a very significant number.
Does that include, I'm sorry to interrupt, Mr. Hari, does that include affidavit requests that were made because I considered the affidavits which had been provided to be inadequate and therefore asked for further affidavits?
I believe that's the full number of affidavit requests, which would include what you refer to.
Yes, thank you.
So many persons have also received multiple affidavit requests, often with the same deadline. Of those 59 affidavit requests, 42 have been submitted to the COI or otherwise dealt with. This has required an enormous effort on the part of the ministers, on the part of the public officials, on the part of the IRU. And the reason is because each affidavit requires extensive work. And just to give some examples, the Crown Lands affidavit is 37 pages. It has an exhibit of over 1,000 pages. The Financial Secretary has had to produce 5 affidavits, exhibiting a total of about 4,000 pages. Not only have several affidavits required exhibits in the thousands of pages, but many more have also had exhibits in the hundreds of pages. So this has been a very significant effort on the part of many persons working over the last months, in some cases without break and in very difficult circumstances, so as to assist as much as is reasonably possible and on timetabling. And I think, just considering the average of what's been done over this period, we've had 2.7 affidavits a week produced over the last 14 weeks. So it's a very significant effort that has been made to achieve this. And I think the other thing is that that's been done alongside numerous other requests. There have been other document requests, factual, legal, administrative issues on which public officials, ministers, where appropriate, and also the IRU have been assisting the COI. So there is a lot of work that's been going on alongside these affidavit requests, all in the context, of course, of the COVID surge, which has resulted in some cases, officials are unable to work on affidavits for periods due to bereavements, and of course the business of running the government and the jurisdiction in this very difficult time. So I think, by way of background, this is something that I should note. The second issue that I would like to address is the point of redactions. And I think the suggestion was made that because the redactions are not a matter for the public officials or the ministers, that they ought therefore to be more readily done. I think the difficulty is there that it does require significant resources in order to go through many thousands of pages and to apply the redactions in the way that Mr. Rawat indicated. It does take significant amounts of time. And so we're having to balance focusing on the affidavits, on statutory bodies and Crown lands, which we understood were the priority and which I'm pleased to say all are now in, albeit all were not able to be put in accordance with the initial deadlines, but all are now in. We're having to weigh up that as compared with also spending days and days going through thousands of pages for the purposes of redactions. And it simply hasn't been possible to do all of that all at the same time. So resources are needed to go through the redactions. And of course, the Attorney General's chambers, the IRU, have been putting resources on redactions, but it's not the case that that resource doesn't have implications in terms of other work that is then needed in terms of, for example, the affidavits. I should also say there is a reasonable limit to what the Attorney General chambers and the IRU can do without instructions or documents or information where it's needed for the purposes of affidavits, for example, with all the support that is being given. If it's not possible for the public officials to turn things around in the timescales that are indicated because of the reality of circumstances, then encourage support, and as much as can be done, of course, is done. But nevertheless, instructions are required. And I think it's really been a tremendous effort on the part of many people to have gotten to the point where we are in terms of having responded on the affidavits in particular.
And in terms of redactions, we have received correspondence to say that instructions are awaited from Cabinet over several weeks. And now the National Security Council, who we are told by you, have not given instructions in relation to redactions. That must have slowed things down.
So I think on the National Security Council point, I believe that you should receive a letter, if not today, then perhaps by tomorrow, addressing that issue, because a waiver has been given with regards to the use of the papers that I think you're referring to for the National Security Council. In terms of the position of Cabinet, I mean, I think it's fair to say that concerns that there have been concerns about the approach of publication of documents in some cases. I think an example that I would give of that is the audit reports which were published on the COI website before they were laid before the House of Assembly. Be that as it may, Cabinet continues.
Those were the reports that were gone through in great detail in the oral hearings.
Yes, they have been addressed in the oral hearings.
Yes.
I think that the concern I was referring to was more that they had not been laid, as would be usual, before the House of Assembly before they were published on the COI website. I think the issue, though, remains is that Cabinet has a policy, government has a policy of engaging with and assisting the COI. That's why we're all here. That's why we're turning around all of these requests for affidavits and documents as soon as can humanly be done. And Cabinet, with regards to the hearing bundle, has agreed to waive privilege. And so, we've again been working to produce a redacted bundle. And as Mr. Rawat indicated, on Saturday, we were able to deliver the 24 hard copy folders that reflected that redacted information. I think it's far easier when we have a specific hearing bundle to put it before Cabinet for a decision in terms of the waiving of the privilege and confidentiality, which is important. And I think what I just referred to shows is that they continue to maintain the same policy of openness towards that. What becomes more difficult is where there's a perception that they are being asked to take a view on a blanket waiver, if that is how it may seem, in a broader context when we're dealing with thousands and thousands of pages of documentation that's being submitted to the COI. And this is where I think perhaps some of the difficulty has lay.
Mr. Hari, I understand what you say, but in relation to the affidavits, where, as you say, some of the exhibits are big, hundreds or thousands of pages, but I have asked for the affidavits to address specific issues, and those issues have been addressed, and the exhibits are the documents that the deponent of the affidavit considers irrelevant. So I think there's a really good chance, if the affidavits have been put together properly with proper advice and proper focus, that we will want to put into the hearing bundles on any topic the affidavits and the exhibits which you say are relevant.
Well, I think there's 2 points, if I may, on that. The first is the simple one of resourcing, which I mentioned earlier. The more time that is spent on going through documents for the purposes of redaction, the less time that can be spent on moving past these 42 affidavits that we've submitted towards getting through the remaining ones. And so there are very real resourcing and trade-off times. And I know Mr. Rawat says, well, you've got a team and you're resourced, you know, and there shouldn't be any issue. But the reality is that these are the constraints that we are facing. There have to be some trade-offs, and it does take time. And so that's the first thing I would say in response. The second thing is that, you know, in some cases, it's not entirely clear that all documents will be referred to or would be published. And I can give as an example the belongership affidavit, in which cabinet memoranda for belongership applications have been asked for over a 10-year period. In some cases, they're very broad what's asked for. All documents related to certain issues, all minutes, all correspondence, and so on. And in those cases, it's far more difficult to see a proportionate approach where it's necessary, or shall we say, as much a priority as working on the affidavits, to spend days, which have been spent on redactions, no mistake, but you know, more days. It's a question of how helpful is that as compared with focusing on the affidavit. So these are some of the very real issues.
Well, Mr. Hyde, I certainly appreciate that that some of these requests require a substantial amount of work, particularly by the public officers to whom the task has been delegated by the ministers in most, I think, possibly all cases. Looking at where we are now, because we are now in the hearings, we are now considering the matters where these affidavits have just been put in, some haven't been put in yet. So there is, I think there should be a focus on how we can proceed from here, particularly in relation to statutory boards, which is starting now. And is there any difficulty that you can see about the proposal for statutory boards that Mr. Rawat's made, which is essentially that we, the COI team, and you, the IRU and the AG and those you represent, use the COI bundle, and a copy of the redacted bundle that will need to be updated because affidavits came in yesterday. Those haven't been sent in a redacted form yet. That bundle is given to Silk Legal if indeed they are going to attend any of these hearings. Given that the pagination is the same, I would have thought that this is a logistical problem, which a logistical issue, which could be pretty easily resolved.
I am, I think, going to need to take instructions on the point. I understand the proposal, and there are a couple of reasons why I say I think I'll need instructions on it. One is that the redactions in the bundles that have been put in exclude information from cabinet minutes that is not relevant to the specific topics, whereas I don't believe the COI hearing makes allowance for those redactions, issues of relevance, what may not be relevant, what isn't relevant in cabinet papers.
Those parts of the minutes simply aren't going to be referred to by anybody under any circumstances. Mr. Rabbit isn't going to suddenly, in the middle of statutory boards, raise a point on a document that has nothing to do with statutory boards from a cabinet minute. And if he does, you can leap in and stop the hearing. You can stop the live streaming of the hearing. I just don't see any difficulty.
Yes, well, I think that's I accept that point, that it's unlikely that there'd be reference made to it. So it may be that a practical view can be taken on that point. The second issue is with regards to the CVs and the issue of personal data, which I think Mr. Rao referred to as a distraction. I mean, I think in that case, as he would know, the IRU team has spent a lot of time trying to engage with the relevant individuals. We're dealing with more than 100 CVs in this context, so as to seek their consent for their CVs to be published. In some cases, we've had responses that they've not agreed to publication. In some cases, there have been agreements to publication. So I think, again, that would be a difference in terms of the issue of redactions. And we have in mind, in particular on this, the Data Protection Act, which came into force in the BVI on the 9th of July, 2021. So I think that's another reason why I think I'd need to take instructions on the proposed approach, and could endeavour to come back very, very quickly on that.
Mr. Hyder, without going into the law, which we don't have to do, in relation to these personal data, the first point is that you have sent these to us. You've sent these data to us. We have them. We're not going to publish them without, well, I would have thought we were not going to publish them in any event, but we're certainly not going to publish them without clearing that with you and with the owners of the data, I wouldn't have thought. Secondly, you say that the attorney does not propose relying upon any of the CVs, any of the data in the CVs. As Mr. Rowett said, at present, so reliance could pop up at any moment. But the letter in which you said that seemed to me to be based upon a false premise. You say you're not relying upon it because the competence of the individuals is not in question. Well, the competence of the individuals is not in question. We're not here to look at the competence of individuals in that sense. But I would have thought it would be possible that the attorney and those she represents may want to rely upon the CVs in this sense. That is, when we look at the process, how statutory board members were removed and how they were appointed, I imagine that at least in some cases, the CV may have been taken into account. And therefore, that's something which an individual public officer may want to rely upon. And so I'm not sure that you're saying that the attorney doesn't propose to rely upon them is based upon a true foundation. But third, and perhaps most importantly, in any event, it seems to me, Mr. Rowett can obviously speak for himself, but it seems to me that it's unlikely we're going to get into any detail of any of the CVs, because what's going to be important in terms of process will be if the CV was taken into account, probably more than the content of it. The content of it may conceivably raise its head in some cases, but it's really going to be whether the individual who was part of the decision-making process took into account the individual's CV. So I just don't see that there's going to be any great practical difficulty in dealing with this. We're dealing with these data.
Well, let me come back to you, Commissioner, on the suggestion of using the COI bundle, which is that I'm instructed that we can proceed on that basis and use it. think the only point that's made is that obviously Silk Legal wouldn't have access then to non-relevant material, such as in cabinet papers. But I think with that proviso, I think we can agree, which hopefully is a constructive way forward on that.
Yes, and quite quickly, please, because we're starting with these witnesses who are going to be using this bundle, as I understand it, tomorrow morning. Now, Mr. Hyrie, is there anything else you want to say on this head?
Not on this head, sir, no.
Mr. Rowan.
So, can I may have misheard the last point that Mr. Hyrie made. That is the proposal is that Silk Legal receive the redacted version, so they will not see irrelevant material. Because as I understand it, the redacted bundle as provided by the Attorney General has removed from cabinet papers all irrelevant material, and so that is the protection that proposal affords the attorney. So I hope that's clear. Just to return,
that's correct. Yes.
Thank you. Just to return to the question of CVs. I think what I can say is this: we will all take care, and we all should take care, and that includes witnesses and other legal representatives in how we use personal data. But we are in a situation where we need to get on with the hearing, but also the question of CVs, and you've drawn attention to this. They may arise as relevant. If they arise as relevant, then that will be canvassed during the course of the hearings. And of course, people will need to be proportionate about the extent to which they need to refer to a particular CV, but we cannot exclude the possibility that a witness, be it an elected minister or be it a permanent secretary, needs and wants to refer to this material. I think I'll return to the Data Protection Act under another head, if I may.
But that can be dealt with, can't it, Mr. Rowett, by a combination of things. Firstly, the fact that either you or those representing the individual or those representing the AG, which may possibly be different, will take great care not to divulge any personal data, at least without giving me notice that that's what they're about to do. And we can tell witnesses that that's an important constraint on them. Over and above that, we have the 3-minute delay. And if necessary, we can go into a private, non-live stream session to deal with any issues that might arise, because you're right, issues might arise. Not many, I think, but it's certainly possible that they might arise. But those seem to me to be adequate safeguards against the inappropriate disclosure of personal data.
And I mean, the reason I return to the issue is that I don't want anyone to be under the illusion that if something is referred to at a hearing, it cannot then be referred to in your report. Depending on what the witnesses say, you may need to refer to material that is in an affidavit.
Yes.
And that's important for us to keep in mind.
Yes.
And there are circumstances in which inquiries do need to refer to personal data. I mean, the names of people who may have died in an accident is personal data. Their ages is personal data. The names of their relatives or whether they had children of a certain age is personal data, and such material is referred to.
Yes.
And so one has to put it in that context. But I think we've reached a point, at least on that issue, where subject to Mr. Hyrie confirming his instructions, we may have a way forward that allows us to proceed with tomorrow's hearing.
Yes, thank you.
Can I turn to the second topic, and that is the question of the position in relation to the elected minister's response to a position statement produced by the governor. You have already alluded to this with the reference to the National Security Council, but again, to give it some background and context, you asked a number of participants, all the participants, but also a number of those who with an interest in government, institutions and individuals, to submit position statements on the issues of governance and law enforcement and justice. Those position statements have been published on the website. You made an order, and it's order number 15 on the 30th of June, Commissioner, which allowed participants to respond to criticisms made of them by others in their position statements. And those responses had to be in by the 12th of July. The order referred to the need for the response to be in the same format as you had previously directed for a position statement. And that meant that what was expected was that at that point, somebody putting in a response would also identify any redactions they sought and would, as we've said, produce effectively, you produce documents in three forms: unredacted, shaded, and blanked out. And that has been the approach we've been adopting since late May to try and keep the show on the road, so to speak. And that is important because I noted a moment ago that Mr. Hyrie pointed to resources, limiting the work that could be done, identifying redactions when the focus was made on producing the affidavit. But what I must point out is that the letters of request for affidavit asked for redactions at the same time as the affidavit was being produced. And the position that which is the position of concern that the attorney has adopted, is that she doesn't, in relation to matters like LPP or public interest immunity, identify what redaction she seeks, which are matters of legal argument ultimately, potentially, but simply says, I reserve the right to do so. And that is not helpful. But if I go back to the position of the response, in relation to that, the ministers, elected ministers, for their response, sought and were granted extensions. They provided the response on the 16th of August. No redactions were sought, and they were therefore given by you till the 25th of August to indicate the position. There was a response on that day, but without any real specific detail. But what was said, and it's a point that you have alluded to, and that was that documents had been provided as part of that response, which required the consent of the National Security Council and the Joint Task Force in terms of whether, it wasn't entirely clear, but whether there would be a waiver over redaction or a waiver over publication or a waiver over use. What wasn't explained, bafflingly, was how the elected ministers were able to actually hand over those documents in the first place without having received the consent of either the National Security Council or the Joint Task Force. What you directed, therefore, on the 26th of August was that the position of the National Security Council in relation to publication of the response on the website of the COI be clarified, and that 2 copies be provided of any document for which redaction was to be sought. And the deadline for that was the 31st of August. On that day, the response was received that the Attorney General needed more time, and the response from the COI was to ask when a substantive response would be forthcoming, and whether other redactions were being sought. The position was that the only answer was that the Attorney General had yet to receive clarification of the National Security Council's position, but no response was also given as to whether she would be seeking any other sort of redactions. So, and I appreciate that Mr. Hyrie may have alluded to this if I heard him correctly, but what we need to know now, because it does impact on the hearings, we will want to have a hearing on governance at some point. Firstly, if there is a substantive response, what is a substantive response? Secondly, and how is it that the ministers could disclose National Security Council and Joint Task Force documents when consent had not been obtained? And thirdly, if there is any reliance on public interest immunity, what is meant by that? And finally, if there is going to be, in relation to the response and the documents exhibited to it, redaction sought on any other basis, and if so, what those bases are. It goes back to the point that you made earlier. the documents here are not those are documents that the elected ministers say it is important for you to see in order to understand their response to criticisms made of them. And so they have assessed those documents as relevant. And it isn't enough for them to say, well, it's for the commissioner to see and the commissioner to see alone, because in order to understand, if they want you to understand their position, they also need to understand that you will need to refer to it, possibly at a hearing and possibly in your report. So I pause there again and would just invite Mr. Hyrie just to clarify the position.
Yes, Mr. Hyrie.
Thank you. So I think the position is hopefully relatively straightforward in terms of moving forward. The NSC has approved a waiver of public interest immunity confidentiality with respect to some pertinent points in their papers, and I believe that those are going to be uploaded to relativity in redacted form today. There is no other confidentiality or immunity that is claimed with regards to the other papers that were appended with the minister's response. And so you will be in a position as of today to publish the minister's response to the governor's statement along with all of the appendices.
So can I just check one thing? I may have misheard Mr. Hyrie, but he said that something is going to be uploaded, that the document will be uploaded in redacted form. That's one of the questions we raised and have been raising. What is the basis for the redaction? When is the application for redaction going to be made?
What are the redactions? We don't know what the redactions are.
Until we see them.
Yeah.
Until you see, well, the redactions are certainly for relevance. The NSC papers are, of course, confidential. There is a high level of confidentiality around them more generally. They were given to the COI in confidence, of course, in terms of the two-stage process. Of course, we rely on assurances given in that respect. So I think that's hopefully clear that it's not intended to have general publication of National Security Council meetings other than what's particularly pertinent to what is said.
Does that mean that in respect of the redacted version, which you're sending us hopefully today, you will identify obviously everything that you wish to have redacted and also the reasons for those proposed redactions?
That's correct, that the redactions will be given in what is uploaded. I hope from what I've just said, as well as the fact that you also have the unredacted version given on a confidential basis, it should be reasonably clear as to the reason why, for relevance, for example, there have been those redactions made.
With respect, it will be reasonably clear because in the covering letter, you're going to say what the basis of the redactions are. If it is that you don't consider relevant parts, say, of the NSC meetings, which I quite understand, both the importance of that and also its force, then just say that will make things a lot easier.
We can understood. We can do that in the cover letter.
And then hopefully my task in agreeing the redactions will be really straightforward.
Yes.
Good.
Could I just before we move on to the next topic, just check one thing? What there is obviously a response from the elected ministers together with annexes, which are documents. Could Mr. Hyrie just confirm that there are no redactions being sought in relation to the response, I take it? Are the redactions being sought just in relation to the annex documents?
Your question was, are the redactions sought just in relation to the annex documents? Or sorry, if I didn't quite follow.
As I understand it, that there is a written response which sets out the position of the elected ministers.
The answer to your question is yes. The redactions are only with reference to the appended documents, because once it's in the response, obviously it's relevant.
Right. And so what will come in your covering letter will say, these are the redactions sought and they're sought on this basis.
Yes, it will.
Thank you very much.
Thank you very much, Mr. Hyrie.
Could I move on then, Commissioner, just to a topic that Mr. Hyrie has referred to, and that is the question of belongership. On the 29th of July, the the COI sought an affidavit on this matter from the Minister of Natural Resources and Immigration. On the 24th of August, the IRU confirmed that it had made disclosure and that it would be providing a short affidavit relatively shortly. The point was made in that letter that that in terms of the disclosure, appendices were not included. And then what then followed was that on the 26th of August, the COI wrote to the IRU expressing concern over the way in which disclosure had been provided, and in particular, that it had been provided in redacted form. And the position as set out in a letter sent to us on the 1st of September, and I hope I'll try and summarize it shortly but fairly, was that documents had been removed because they contained sensitive personal information, and that was in line with data obligations. And that's Mr. Hyry's point about the Data Protection Act. Now, what the letter says is that, firstly, to use the material, we would need the consent of the individual concerned, and also we would need to give the IRU good reason. And so this seems to be a shift in terms of disclosure to the Commission, because your protocols that you have issued make clear that you expect to see material in unredacted form. It makes clear that you will ultimately be the arbiter of relevance. And it adds an additional caveat, because not only must you seek consent as Commissioner, but you must also give the IRU, and I assume that's the Attorney General, a reason for why you should have the material, and she will then be the judge of relevance rather than an independent Commission of Inquiry. What would, in my submission, assist you today is some explanation of the legal basis for the stance that is now being taken in relation to this affidavit, particularly because it hasn't been taken in relation to previous affidavits. Now, I know that Mr. Hyry earlier in submissions, and he used the example of belongership as an example, but he pointed to the fact that there had been requests for documents spanning a number of years. What I would point out is 2 points. Firstly, the terms of reference of this Commission are wide. And as I've said, you determine relevance. But secondly, the approach that needs to be taken in response to requests for affidavits is that they can be easily distinguished from requests for disclosure. An affidavit, all the affidavits have been put, request, set out questions and request information that you have said is already relevant to the work of the Commission. And so what the recipient of the affidavit is being asked to do is direct their mind to those questions, and direct their mind in such a way, what they are told is this is material that could be used in the hearing, which is why we always ask about redaction. And so, we're struggling to understand the basis on which data protection means that in some instances, the Attorney General through the IOU can disclose material which has sensitive personal information, such as the CVs, but in others, it's not required to. So I'll pause there, and perhaps if just Mr. Hyry could clarify his position in relation to the belongership affidavit.
Yes, thank you. Mr. Hyry.
Yes, thank you. I think it was said that there had been a change of approach and no precedent for this issue with regards to extremely sensitive personal data. Of course, the belongership applications involve extremely sensitive personal data of a particularly sensitive nature, including to do with the state of children, marital relations, including to do with financial information, disability sometimes. So they are extremely sensitive. And in the context of the hardship applications, the same approach was taken as has been taken here, which is that if it's necessary and proportionate, and the Commissioner wishes to see the information, then that would be given. But this information is not all being given in a blanket way without that initial screening threshold. And so we have said that in circumstances where more information is intended to be sought about a particular person, the names have all been given, as they were with the hardship applications, then that's something which can be done. And the reason is that even before the BVI Data Protection Act of 2021 came into force, and it's on the 9th of July of this year, so after the protocols, but relevant to this specific issue, there's the UK GDPR, which similarly has particular provision with regards to sensitive personal data. So that is the reason, and what is proposed is hopefully an approach that allows for what's necessary and proportionate, but doesn't just simply hand over 10 years worth of belongership applications with that very sensitive personal data without it being necessary and proportionate. I think the only other thing I would say, because Mr. Rowett comes back to the issue of when affidavit requests are made, the issue of relevance is stated at that stage. I think what we have and what's provided in the rules is a two-stage process, and that two-stage process we had understood would involve a secondary stage when particular relevance for publication was sought. Now, by asking for redactions to take place across the board in all documentation that is included in a response, essentially what you have is a kind of conflated process, and it does come down to resourcing again, because while a lot of time is spent on redacting thousands of pages that are appended to affidavits which may not necessarily need to be published, or may not want to be published, that's time that's not being spent on working on the affidavits themselves. So there is some in a sense challenge here in covering all bases, and it is very time consuming to do that. So it's a question of priorities, and the reason we focused on the affidavits, and particularly the ones identified, is because we've understood that to be the particular priority. So I hope that also helps to explain that issue, because simply by saying in the request this is broadly relevant, it still doesn't help to address the resourcing problem. And relevance also maybe a matter of degree, because I'll give an example. The Crown Lands affidavit had 22 questions. One of the questions had 13 sub-questions. So it may be of interest in that sense of relevance. And of course, relevance is for the Commissioner, but I don't think that it's necessarily the case that everything that comes back in all of those responses is necessarily going to be published. It would seem to us to be a different question.
Could I respond? I mean,
yes.
I think it's important to clarify what is meant by being published. As I've said, we are not, or we have put limited amount of material onto the website, and that has been done for specific purposes. So to take the example of the Auditor General's report or the Internal Auditor's report, that the reports that were published were done after there had been significant, in relation to the Auditor General's 2 days worth of evidence, going through reports in detail. So we need to make a distinction between the publishing to the world at large and publishing for the purpose of a hearing, because that is the stage at which we're at. And when we publish, as we have done, by giving a hearing bundle to a witness and to participants, and the Attorney General has received hearing bundles that relate to witnesses that she does not represent, we are not publishing to the world. And so that's an important distinction. But Mr. Hyrie refers to the two-stage process. With respect, it is not been conflated. The first stage, and the first stage is particularly important to the question that we are now discussing, is that material is disclosed in unredacted form to the Commissioner. And the Commissioner asks for that material that he considers relevant to his work. that's the first stage. The second stage relates to the possible use of that, either in a hearing or in the report, or if it needs to be published more widely, for example, on the inquiry's website. What has changed only is that we have sought, for reasons I've explained, participants to give to set out what they want redacted at an early stage. And if one, I'm sorry, we're going round and round slightly, but Mr. Hirey has pointed more than once to resources. But the point that the Attorney General has made, and this was made by Ms. Knock in submissions on the 8th of July, the point that was made loud and clear is, I'm not doing this. I'm not complying with this protocol. What I'm going to do is just reserve my right to do so. Well, if one works it through, even if the attorney does do that, then at some point she's going to have to go, or her lawyers working for her will have to go through the documents to identify where they wish to raise LPP and where they wish to raise PII. So that exercise will have to be done. All we are asking to do is do it earlier rather than later. Because if you're producing an affidavit, it's likely to make its way into a hearing bundle. That's the point. And so the exercise has to be undertaken. And the position that we're in is that if that exercise is going to be undertaken at the very last minute, then that causes significant disruption to the timetable. But to return to why Mr. Hirey, the reasons Mr. Hirey has given for why a differential approach has been taken to belongership, that, with respect, doesn't answer the question, and it doesn't answer the basis on which it was set out in the letter. The letter said that what the reason was because of the need to comply with data protection obligations. And so, what the question then becomes is, firstly, well, what are those data protection obligations? Why have you now sought to rely on them when previously you haven't? And then in circumstances where you are told and you know that the material A is sought by the Commissioner and B is being given on a confidential basis, what is the justification for ignoring it? Because if there is justification, then it means that if the Commissioner issues a summons tomorrow for that material, the Attorney General will not comply with that summons.
Well, I think in response, Mr. Rawat, I'm not sure if you heard the part where I said that it's not a change of approach, because with regards to the hardship applications, again, there was the issue of extremely sensitive personal data. And in that case, what was said is if it's necessary and proportionate, it will be handed over. That was the position that was accepted by the COI at the time. So it seems that if anything, there's a change in position from the COI, not from the Attorney General on this. I think the other thing, as I mentioned, that's very relevant is the timing of the Data Protection Act. In that context, the GDPR was relevant to the point, and indeed, still would be. But the BVI Data Protection Act of 2021 came into force on the 9th of July 2021. So that is a relevant consideration. And again, the Attorney General is not saying the information will not be given. All the names have been given. What is said is, where it's necessary and proportionate, then all the extremely sensitive personal details will be given, but not where it's not necessary and proportionate.
Yes, I mean, given that the attorney's position hasn't changed, and therefore there is no bar on the data being handed over to the COI, I'm struggling to see what the legal basis of the objection to giving the COI this information is. But how can we progress this, Mr. Rawat? I mean, there's, as I say, at the moment, from what Mr. Rawat says, there is no legal basis for the objection, because he says that if we ask for the information and set out that we do want to see it, it will be disclosed.
Well, that has been done. The letter of request set out what information was sought. The protocols make clear that material is handed to the Commissioner on a confidential basis. What the attorney wishes to do is to insert herself in the process by being the person who determines whether it's necessary and proportionate to make disclosure. She is now the arbiter of relevance. She's now the arbiter, and she now wishes to control how it operates. But there's no point my going back over the point. What I had hoped is that Mr. Hyrie could point to a provision in the Data Protection Act that allows a participant in a commission of inquiry to withhold information on this basis. Well, I can't add any more than we have made the request and we've set it out, and that is a request.
Okay, I understand. Maybe a constructive way forward, perhaps, Mr. Ra, if perhaps you might explain to us, and perhaps we can take this offline, but how the BVI Data Protection Act, how its provisions allow, as a matter of BVI law, the provision of this information in this context, then maybe we can find a way to go forward in that respect.
I'm quite happy to do that, although I'm somewhat surprised. I'm quite happy to talk to Mr. Hyrie offline, but I'm somewhat surprised that, given the letter from Withers specifically refers to data protection and obligations, they had not considered that question themselves before writing that letter. But the point, you know, it's just, I mean, the concern I would have is that if one follows the logic of the submission through and the point made in the letter, then if the current state of the law prevents this disclosure being made, then in circumstances where there has been previous disclosure of sensitive information, the logic is that the elected ministers, by giving that information, were in breach of their own data protection obligations and would now be under a duty to go and contact all of those people whose data they provided to the Commission and explain that they have breached those people's data protection rights.
I'm sorry, but I'd said it's extremely sensitive personal data. It's of a different nature, and under data protection legislation, it has a different quality to other information, which is not extremely sensitive. And as I mentioned, I believe a couple of times, the BVI Data Protection Act came into force on the 9th of July 2021. So that is an important new element in timing terms on this issue.
Well, I think the first step, Mr. Hyrie, because I certainly don't understand this, but I'm sure you're able to illumine us, is that you write to the Commission setting out the basis upon which this disclosure has been withheld, referring, I assume, to the 2021 Act, and then we can consider that basis, because at the moment I don't understand what the basis is.
Yes, we will put that into a letter. And just to praise it, it's sensitive personal data, and it's section 7.1 of the Act, which says that a data controller shall not process personal data about a person without that person's express consent. But we will put it into a letter in more detail.
That would be helpful, and then we can take it from there, Mr. Hyrie.
Thank you.
Good. Thank you very much.
The next topic, I hope we can take this shortly, because Mr. Hyrie has given some indication already of the state of play. He's referred to 59 affidavits being sought and being provided, and as he confirmed to you, Commissioner, some of those had to be provided because the original affidavit didn't really fully comply with the requests that have been made. So far, we have 42 that have been submitted on Mr. Hyrie's maths. He has
I believe 2 were withdrawn as having not been relevant. So I think I said 42 submitted or otherwise dealt with. I think it's 40 submitted. Just sorry on that.
I'm not going to argue over that number. I'm quite happy to accept either 42 or 40. But the point is that there are a number outstanding, and what would, I think, assist you, and again, it assists us in terms of planning, because helpfully the IRU produced a table at your request, Commissioners, setting out the state of play, and that table usefully identifies who was delegated to make the affidavit, when it was originally sought for, how many extensions were requested, and then the date provided. But in relation to some of the affidavits, they are marked in terms of date to be provided as to be confirmed. And it's just really, perhaps, if Mr. Hyrie could give you some comfort in terms of when affidavits can be expected?
And this is important, Mr. Hyrie, because we are planning the hearings, and you are saying to us, we want to know what the timetable is. We want to fix the timetable. We can't fix the timetable without the basic information, some of which was requested several months ago, but certainly several weeks ago. We simply cannot organise the timetable in a sensible and efficient way.
And I think if you know, we are able to get some input, as you had helpfully done previously with regards to the focus on statutory bodies and Crown Lands affidavit, that will help us, because, as I've said, there are a lot of things going on in terms of affidavits, in terms of redactions, responses to other requests for legal input, in terms of administration of bundling and so on. So I think that will help us to expedite and focus on those things that are most proximate in terms of chronology as well. I mean, I think you know, we have some sense of that, but anything that you can, you know, indicate on that will help us. I can't give exact dates for specific affidavits, as I hope would be understood, because we are necessarily reliant on public officials and ministers who are working, you know, very hard to assist. But there are obviously instructions that need to be obtained, documents collated, and so on. And as we know, the state of record keeping in the Virgin Islands is not in a good place. It actually comes back to the point you started with, in part at least, which is this being the anniversary of Hurricane Irma 4 years ago, and record keeping has been significantly affected by that. But there, I think, are other long-standing issues to do with record keeping. Certainly not ones that the ministers who came into office in February 2019 are personally responsible for, but, you know, doing all that they can to support and assist on that process nonetheless as well.
But how can we timetable topics such as particular contracts, Crown leases, etc., without having any idea of when, if at all, we're going to get the basic information that we've requested? How can that be done?
Well, it partly comes down to the prioritization. I think, as I mentioned, the Financial Secretary has put in 5 affidavits dealing with more than 4,000 pages. So I think if recipients can know the order in which they should be prioritizing working on their respective affidavits, that would certainly be of assistance.
Well, it's certainly extremely disappointing that some of these affidavits, which have been outstanding for some time, we have absolutely no idea when they might be ready, nor, even more worryingly, do you. But as I say, we will simply have to do what we can. If there's any further focus that we can give you, we will. But I've identified those matters which are of interest to me. That was done weeks ago, and it is very frustrating that we cannot timetable these topics in a sensible and efficient way, because we simply do not know when, if at all, we're going to get the basic information from the government. Mr. Rawat.
What assistance we can give is, and this was why we asked for statutory boards and Crown Land to be prioritised in July, because they were the next topics in line. What we have tried to do is to go through the topics in the order that you set them out in June. We have had to put governance off because there was still responses being received, and I've set out the sort of chronology of the time it's taken the elected ministers to come up with a response. We cannot do governance until we have got that resolved, and so that's one issue. I mean, governance will now have to come after statutory boards and after Crown Land. I think once we've done statutory boards, in an ideal world, we would like to do Crown land. But I mean, I think we've ended up in a circular position because Mr. Hyrie says, well, if you tell us the order that you want to do things, we have done, then we will try and follow that order. But the problem is that we cannot keep to that order if we don't get the material. And if, for example, there is delay in providing an affidavit or an issue arises over its redaction, which risks us losing hearing time, what we would want to do in that event is to bring another issue forward or bring another witness forward. In an ideal world, we would, of course, want to follow the order because it is important that the public understand how we are working. But we do have to be flexible, and that does mean maybe calling witnesses out of turn or at different times, even if they go to another topic.
I think Mr. Rowett makes a very good point. I've said from the outset that I propose to deal with matters flexibly, but given the current state of play, there will inevitably be a need for greater flexibility because we have to get through this work. And in circumstances in which we simply don't know when we're going to get basic information from the government, that will mean that we have to be increasingly flexible. But statutory boards, for example, which were due to start on the 19th of July, we're starting them today, and 2 of the affidavits arrived quite late last night. So it puts the Commission in an extremely difficult position. As I said at the outset, whatever difficulties we face, I intend to press on as best I can. And if that puts, well, I intend to press on as best and as quickly and as efficiently as I can. And I expect the BVI government to be supportive in that object. I think, Commissioner, as I understand it, Ms. Hyrie, you can't give any further information on these outstanding affidavits.
I mean, there was a very detailed document which Mr. Rowett referred to that set out the state of play of the respective affidavits. And then I can come back with indications of when we think we may be able to submit respective affidavits. I mean, as I said, these 42 affidavits have required an enormous effort, late nights, weekends, ministers, public officials, and including, as you say, yesterday when there was a power outage, public officials still working on their affidavits. So I think a huge effort, sincere effort, a good faith effort has been made. We put in all of the affidavits on statutory bodies. You'd indicated Crown Lands was next. That's also been submitted. We're working very hard, and the government, maintains its approach of working, constructively to try and assist. So I can come back with best indications on timing if that's helpful, and if we're able to get any further guidance, because there are a very large number of issues that are still being considered for focus. That would certainly be of assistance to help us to help you, as it were.
Yes, certainly if by, say, the end of tomorrow, you could come back with best indications of the affidavits on your table that are outstanding, where you've simply put in to be confirmed. If you can give us dates, then we can work up a timetable for the next few weeks. Yes, thank you very much, Mr. Hyrie.
Commissioner, I think the last topic that we need to return to, and that is just to return to a matter that you canvassed with the participants on the 13th of July, which was and followed on from having sought written submissions from both Silk Legal and the Attorney General, and you sought those submissions internally as to the definition of the words corruption, abuse of office, and other serious dishonesty that appear in paragraph 1 of your terms of reference. At the hearing in July, you heard submissions from Mr. Olympitis on behalf of the Attorney General, who seemed to agree with a proposition that you put to him. I think what I would do is just invite you just to seek some clarification from Mr. Hyrie as to whether the Attorney General agrees with the position adopted by Mr. Olimpitis at that hearing, which appears to be from the transcript that he, without caveat, agreed with the proposition that had been put to him.
Yes, thank you, Mr. Wright. Can I just put it a slightly different way, Mr. Hirey? Because obviously I've seen your letter of yesterday on this, on the 5th of September on this, and the reason the hearing with Mr. Olimpitis in July on the scope of paragraph 1 was so short is because I firmly thought that this was common ground as between the AG, Silk Legal and me. And if it's not, then I will need to make a ruling on it. But I think it probably is. I just want to make sure that there is no misunderstanding. The propositions I put to Mr. Olimpitis, or at least let me put these propositions to you, and then we can work out if there is any difference between what you've said in recent correspondence and my understanding of what Mr. Olimpitis was agreeing to. We can at least identify that. The premise is that, and this was set out in our letter, which I think you've agreed with as a proposition, that a public officer exercising his or her public functions must act in the public interest and only in the public interest. Pausing there, is that a proposition with which you agree?
Commissioner, not without caveat. And Mr. Rawat said that Mr. Olimpitis had said so without caveat, but with respect, we don't agree from the transcript.
I do want to hear on this, but can I just make this absolutely clear, because this is really worrying to me, not in terms of, I'm terribly sorry, everything's frozen on my screen, but I think that may be due to me. Can you still hear me, Mr. Hirey?
I can hear you, yes.
You've frozen on this screen, which doesn't matter very much because I can see you on the big screen. I think I've probably kicked a lead out, which is my fault. So you say that a public officer exercising his or her public functions need not act in the public interest and only in the public interest, but can act, because the opposite of public interest is private interest, can act in private interest in whole or in part.
No, sir, that's not what we say, and it doesn't follow from what I said either. What I was saying is that there was an important caveat to what Mr. Olimpitis had said. He made an important qualification, and I think to avoid any perhaps misunderstanding, the position as set out in the letter of the 5th of September is the best position in writing. It's very clear, we can avoid any misunderstanding. But what is said in that letter with reference to Mr. Olimpitis' important qualification is that any knowing departure from the public interest must be a serious one. A knowing departure must be a serious one. And so it's difficult to see how that can be the case unless in almost all cases there would be an improper motive. And these are qualifications which are important and as set out in the letter reflect the position of the Attorney General on this subject.
No, my problem is, Harry, is I simply don't understand your letter, but I'm sure that it will become clear. But the first proposition is that a public officer exercising public functions must act in the public interest and only in the public interest. That I would have thought, as a public lawyer, is a pretty trite proposition. But do you say on this proposition, we'll go on from what flows from it, but do you agree that proposition? Or can a public officer exercising public functions act in part in his own private interest?
There must be a knowing breach of the duty to act in the public interest, which is part of what is said in the letter. So that's the issue which is not touched on in your formulation. It's the knowing breach, it's the knowledge of the breach of the duty to act in the public interest, not the public interest as anyone or someone may construe it, but they must know that they're acting other than in the public interest. That's the important element.
But we have to take this in stages, Mr. Hirey. I fully accept, because it's the case, that the public interest has many strands. So when somebody takes a decision in the public interest, there are many strands of the public interest to take into account. And generally speaking, the weight to be given to those strands will be a matter for the public decision maker. I understand all of that. And we'll come on to knowing, which is extremely important. We'll come on to that. But are you suggesting that a public officer can act in his private interests in any circumstances? Because if you say that, there's a big gulf between me and the Attorney General.
I'm not suggesting that a public officer can act in a private interest. What I'm, in the context of their official capacity, what I'm suggesting is that the formulation in paragraph 1 requires a knowing departure from the duty to act in the public interest. That's the qualification that is given, and it's very difficult to see how that could be the case unless there was an improper motive.
Well, but you say improper motive, but and I know that some of the old cases use the word motive. I don't think it's a particularly apposite word here, but we can use it for now. But the important thing is that a public officer, when he's conducting his public functions, does not act in anything other than the public interest. He cannot knowingly, as you say, he cannot knowingly introduce a private interest into that decision-making process. Or do you say that he can? It's quite alarming if you're saying that if a public officer is determining, let's say, a statutory board member, he can positively take into account the fact that somebody has given him a bribe, or a particular candidate's his brother, or something like that.
That's absolutely not the position that is being taken. I think, with response to Mr. Rawat's, narrowing in on Mr. Olympitus's comment, saying it was given without caveat, the point that's made in response is that it was not made without caveat. It was referred to as needing to be serious, important, and the knowing element is a key aspect in terms of the knowing breach of a duty to act in the public interest. In almost all cases, we consider that would require an improper motive as well. So it's not the position that a minister can act in a personal interest, but the important qualification to what was said by Mr. Olympitus is nevertheless, we think, important.
Three different things you said there, Mr. Hirey. Let's just take them in turn. In terms of serious, you refer to the reasonably well-known case of Chapman. Of course, Chapman says what it says in terms of, in respect of corruption. But what Chapman was saying is that if a public officer is doing his public functions, then absent dishonesty or a number of other things, but dishonesty will do for now. Absent dishonesty, he's not going to be guilty of corruption because corruption requires some seriousness. I accept that. But do you suggest that if a public officer takes deliberately, intentionally, knowingly, takes into account something which falls outside the scope of public interest, that is not, so far as he is concerned, serious dishonesty in public office?
If the individual knowingly departed from their conception of the public interest in a way that was serious, and in most cases would have an improper motive element to it, then I think we're not disagreeing on that specific part.
That's what I put to Mr. Olympitus, that if somebody acts other than only in the public interest, he brings private interests into into his actions, then that is serious enough to fall within the phrase within paragraph 1.
I think the word knowingly is the word knowingly is an important part of this, I believe.
So, I accept that, but we're taking the 3 strands of your submissions in turn. The first one was serious. All I'm saying is that if a public officer takes into account private interests in his public functions, that is serious enough, full stop. So, for example, a bribe, it doesn't matter whether the bribe's $10,000 or $1 million. If he takes that into account in making a decision, that is dishonest and falling within the scope of paragraph 1.
No, and so no one is disagreeing with respect to that example.
Knowing, I accept that. That was in the formulation of the proposition. And that's, again, as you indicate, Chapman comes in here a bit, but he must know that he's taking into account in the illustration that I've made, that he's taken into account something in the private interest rather than the public interest.
In the example you give, yes.
Yes, but generally speaking too, he must know. It must be knowing.
Knowing is an important qualification, yes.
I agree with that, and that was in the formulation of the proposition that I put to Mr. Olympitus. And then you say improper motive. As I say, I'm not sure that motive is the right concept here, but it will do as a word for now. But the improper motive is that he's deliberately, knowingly taking into account a private interest. That is the improper motive.
When you say taking into account, do you mean acting on a private interest? What do you mean exactly by taking into account?
Yes, acting on a private interest.
Acting on a private interest rather than their conception of what is the public interest. Yeah. Yes,
yes. Yes, more or less. I mean, you say the perception, but nobody could perceive that the public interest, the public interest included private interests.
I think with regards to your example of a bribe, I can see what you're saying, which is that it couldn't possibly be in someone's perception of the public interest where they were taking a bribe. I don't think there'd be any disagreement on that.
Or the appointment of a brother. If a public official appointed his brother to a post, ignoring all other criteria, are you saying that that's anything other than falling firmly within paragraph 1?
Well, I think it would depend also on whether they thought that was in the public interest. They'd have to knowingly do something that was not in the public interest. And if the brother had credentials, met the qualifications, then interest, the fact that it was their brother wouldn't automatically make it in the private interest or put you within paragraph 1. So I certainly wouldn't agree with that.
Because in those circumstances, it wouldn't be the fact that he's the brother that would drive the decision. It would be the fact that he was, if this were the case, the best man, or at least an appropriate man for the post.
May have experience, credentials. Yeah.
No, absolutely. But in those circumstances, it wouldn't be the relationship which had been taken into account. Decision maker would take into account the relationship.
No, if the individual if they knew that the brother was wholly inappropriate for the role, and knew that they didn't have any credentials or qualifications, and they were solely motivated that it was the brother rather than that aspect of the public interest, which is having a suitable person, then that's again why the relevant provision is knowingly.
Yes, I don't quite agree with that, because the fact that he is the brother might be simply one factor that is taken into account when making the decision. So I can't agree with you that being the brother can be the only factor. But if it's a factor in the decision-making process, that's certainly wrong and dishonest. And it seems to me it's sufficiently dishonest, it's serious dishonesty that falls within paragraph 1. But what we need to know is, and that was the proposition I put to Mr. Olympitus, and he agreed it without caveat. He said, I put the proposition, and he said yes.
Yeah, I think if you look in the transcript, then a few pages on, there are qualifications that are given with regards to the importance of the issue, as well as dishonesty, which doesn't always necessarily need to be a requirement. But I think there were caveats that were given, and the purpose of the letter was to address and set that out as fully and as clearly as possible, and that's the position that we rely on.
But the letter, which I'm not quite sure entirely mirrors what your submissions today, but what I need to know is there any disagreement between you and the proposition I put to Mr. Limpetus and the propositions that I've put to you today? If there is, I will make a ruling. I mean, it seems to me that I may have to make a ruling because everything seemed absolutely clear, cut and dried. And since your letter, it's not. But I'm afraid I don't find your letter clear.
Well, I think it's as clear a reflection of the position as is taken. And if you feel the need to make a ruling, of course, that's a matter for you. But the position on behalf of the Attorney General is that set out in the letter.
Oh, well, I mean that is helpful. And so I can take it that effectively, I don't need to ask for any further submissions. I can simply rely upon the submissions that were put in July and this letter.
Well, I think if you are going to make a ruling on the matter as you've just raised, then it may be appropriate to have an opportunity for submissions on it.
I mean, we are moving towards hearings that deal with this, which deal with warning letters that have been drafted on the basis of what I thought was the agreement in July, and now at least it's unclear to me whether you agree. I don't find the letter of the 5th of September clear. I don't find clear the differences you draw between the proposition I put to Mr. Limpetus and the position now apparently taken by the Attorney General. But as I say, if the Attorney General says that a public servant in making a public decision in the public interest can take into account private interests in any shape or form, then that is something which he should make absolutely clear, and I will make an absolutely clear ruling on it.
Sorry, was that a sorry, sir? Was there? I didn't. Was that a question to me about whether that's the position of the Attorney General? No. Okay.
Well, that's the position that you seem to have adopted in your letter.
Well, I don't believe that's the way that the letter puts it.
Okay. Do you want another opportunity to make any further submissions on this?
Well, sir, I would say no, except that you say you don't find the letter helpful, which makes me wonder if some further submissions may be of utility to you. The position is reflected in the letter, but it's for the reason that, you know, in response to that I'm wondering if you would find it helpful.
I've got the attorney's original submissions. We've obviously got the transcript of the hearing in July. We've got this letter. If you wish to make any further submissions, I'll give you that opportunity. But this cannot be left in the air if the attorney is taking the view that you appear to suggest he's taking, which is a curious one. But I just want to make absolutely clear that I've understood her submissions. Do I take that nod of the head that you would like some time to make some further submissions?
I'll take instructions and we'll come back to you on that.
If you could do so by the end of today, because we'll have to have the submissions in very quickly, because we are moving on to this very point. But I think you understand the point now. I take the view that if a public official acts, including taking a decision, was exercising his or her public functions, that must be in the public interest and only in the public interest, And if he or she takes into account anything outside the proper scope of public interest, i.e. private interest, that falls within the scope of paragraph 1. If the attorney disagrees with that as a proposition, I would like to know as soon as possible.
I'll take instructions and come back today on that.
Thank you very much. If you could come back later today, Mr. Hyde, that's much appreciated. Mr. Rowett, anything else on that?
I don't think I can assist with any submissions at this stage. Perhaps what, given the indication that you've given to Mr. Hyrie that he can put in further submissions, what I would suggest is that we write to Silk Legal, drawing their attention to the transcript of today's proceedings and invite them by a set date.
We're going to wait for Mr. Hyrie to come back to us. If he says that it's all fine and he doesn't want to put in any submissions, it's all fine and there'll be no further submissions. If he wants to put in further submissions, we will then notify Silk Legal and they will have a similar opportunity. Silk Legal, of course, agreed with that, the proposition too.
Yeah. No.
Good. Anything else?
No, I don't think I've got any further matters to raise this morning.
Anything else, Mr. Hyrie?
No, Commissioner, thank you.
No, and thank you for all your help this morning, Mr. Hyrie. Thank you very much.
Thank you. Commissioner, I think our witness is due at 2 o'clock. So if I could ask you to rise.
Yes, we'll break now until 2 o'clock. Mr. Hyrie, are you returning at 2 o'clock remotely?
I am, yes.
Good. Well, we'll see you and anybody else who links in then. Thank you all very much.
Thank you.
hope you can hear me. Can I start off first of all by thanking you for coming to give evidence? I understand that you would like to give your evidence on oath. Is that right?
That's correct, yes.
And do you have a copy of the Holy Book with you and the words of the oath?
Oh, the words of the oath. I'll have to just go, hang on. Okay, I do have those.
You have that with you, yes?
I do, yes. Yeah.
Right. Could you take the Holy Book in your hand, please, and read out the words of the oath?
Yes, I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Child.
Could I also confirm that you received a bundle from the Commission, a hearing bundle, which has some 33 pages to it?
I do.
And we need to do this just for the purposes of the transcript, but can you confirm that you are alone?
I am alone.
And there are no recording devices operating where you are?
There are no recording devices, no.
We can hear you very clearly, but I know it will help the stenographer if both you and I try and keep our voices up. So I'd encourage you to be louder than quieter if you can.
Sure, no problem.
Right, Mr. Charles, could we just begin, and this is a question I've asked of all the witnesses that have appeared before the Commissioner, just by asking you to give an outline of your background and work history, please.
Sure. Well, my name is Edward Childs. I've resided in the British Virgin Islands since 1990. I work at Smiths Gore, a real estate company, who I joined in 1990. I'm a director of the company, and my role there is commercial property.
So has your work history, if you like, been essentially commercial based?
Yes, it has, yes. So I deal with anything from offices, development property, marinas, hotels. We work both in the BVI and also throughout the Caribbean.
Now, it's right, isn't it, that for a time at least, you were a member of the Climate Change Trust Board. Is that right?
That is correct.
If you have the bundle with you and you go to page 5,
yes.
I'm taking you to sections 4 and 5 of the Virgin Islands Climate Change Trust Fund Act of 2015.
Yep.
We established the Virgin Islands Climate Change Trust Fund. That's at section 4.
Mm-hmm.
It says, and the trust as a body corporate capable of entering into contracts, acquiring, holding, and disposing of real and personal property, suing and being sued, and of doing and performing such acts as a body corporate may legally perform. And then if we go to section 5, which has the margin entry objectives of the trust, amongst those objectives was that the trust shall seek to facilitate a link between domestic and international climate change finance sources, B, serve as a catalyst to attract investment to implement a range of priority climate change adaptation and mitigation projects and programs in the Virgin Islands, and C, serve as the national implementing entity for the Virgin Islands. Now, that's language that probably delights lawyers, but from your perspective, what was the purpose of the Climate Change Trust and of the board?
Well, the trust itself was obviously established by this act. As a fund, it was there to support initiatives within the BVI that were engaging in climate change projects. It could be anything from education within the school environment to somebody wanting to do some kind of green energy, maybe solar panel investment, something like that. So the trust fund is very much supporting those initiatives from the private sector. People could apply to the fund for money, and and the fund would then consider the application and make a decision as to whether or not to support it. There would also be ongoing checks to make sure that the people who've been given money, made a grant, would be performing correctly from the point of view of what they were given money for, and the project was implemented according to certain criteria. The board itself was like any statutory board, is there more in an oversight position, and underneath the board would be a secretariat, which would actually do the day-to-day operation of the fund.
Mr. Rowett, just before you ask your next question, if you don't mind, apologies, but I don't believe that I or any of those instructed by the Attorney General received the 33-page bundle you referred to. I'm sorry if we've missed it, but may I just ask on that, please? It would be very helpful to have a copy.
If you don't mind, Bishop, I can just check with those who sit behind me.
Of course, yeah.
Rather than spend time checking whether it was sent and when it was sent, I think that the swiftest way of dealing with it is just for it to be sent to Mr. Hyrie and Miss Peaty, so that they can access the document as we're going through.
I'm sure that's right. I think it's been sent somewhere, Mr. Hyrie, but we'll simply email it. It's a short bundle.
Grateful to receive it. Thank you.
Thank you. Unless Mr. Hyrie has any objection, I propose that whilst that's being done, I'll just continue with my questions. Mr. Charles, again, trying to sort of summarise it, and please correct me if I get this wrong, but the board then was the oversight body for a trust which was intended to take steps such as raising finance for climate change projects, facilitating private-public partnerships, and generally driving forward a range of climate change initiatives. Would that be a fair summary?
That would be a fair summary indeed, yes.
Now, and that's reflected, isn't it? If we look at page 6 and section 6 of the statute, there are a range of functions allocated to the trust, which includes financial support, supporting actions to build ecosystem resilience, for example.
That is correct, yes.
Now, could you just tell the Commissioner, when were you first appointed to the Climate Change Trust Board?
I was first appointed in 2017. I believe it was around in July 2017.
We have amongst the documentation that we've received a date of 15th of June 2017. Does that sort of match your recollection?
Well, I think my appointment letter didn't come until I've got a note of 7th of July. So that's when I received an appointment letter.
I see. Oh.
It may well have been that there was some approval within government in June, and then I received a letter on the 7th of July.
And that letter would be the document that would formally appoint you to the board?
No, that was a letter informing me that I had been appointed to the board, and then we had an instrument of appointment.
Thank you. And prior to that appointment on the board, had you served on any statutory body before?
Not a statutory body, no.
Any other kind of public body?
Yes, I'd been on other committees within the BVI. There's the Economic Advisory Council. The government did something called a McKinsey report, and they had various bodies, various committees, and I served on some of those committees as well.
So as well as bringing your commercial expertise to this board, you would have had some experience of serving on committees and bodies charged with various functions?
Correct, yes.
If you turn, please, to page 12, or sorry, page 11, first of all.
Okay.
you see there, and it's section 12.1 that sets out the makeup of the board. And so at that time, the board came under the Ministry of Natural Resources and Labour. So there were ex officio members, which were the permanent secretary, the financial secretary, and the chief executive of the trust. But also there were to be 6 other members appointed with the approval of cabinet by the minister. And at that time, obviously, it would be the Minister of Natural Resources and Labour. And these were a private sector representative of the tourism industry, private sector representative of the financial services sector, private sector representative of any sector responsible for making contributions to the fund and already represented on the board, a representative from an academic or research organisation ordinarily resident in the territory, a representative from a non-governmental organisation or community-based organisation ordinarily resident in the territory, and an individual ordinarily resident in the territory. So the makeup of the board would have been dominated by 6 non-governmental individuals. Is that right?
That's correct, yes.
And that's the cohort that you came under?
That's right.
Sorry, could you start your question again? The audio blipped out.
I'm sorry, I'll say it again. So just can you confirm again, please, Mr. Child, that Section 12 provides for 6 non-governmental appointees. That's right, isn't it?
That is correct, yes.
Those appointees make up the majority of the board.
They do.
And that's the cohort of appointees that you fell within.
That is correct, yes.
If we look now to paragraph at the bottom of that page, it sets out there that in appointing those non-governmental appointees, the minister has to be satisfied that such persons have the necessary expertise and involvement in the sector for which they seek appointment, no conflict of interest, including related to political affiliation, and the capacity to do one or more of the following: attract financial support for the trust, ensure effective financial management of the trust, provide sound and effective decision-making leading to the attainment of identified functions of the trust, and provide effective leadership and direction to the board. Now, against that background, could you just outline for the Commissioner your experience of of the appointment process for you?
Sure. Well, first of all, I saw the Climate Change Trust Fund. There was information in the press, probably about 2015, that the Climate Change Act had been passed. And then shortly after that, there were adverts inviting people to apply for a position on the board. And it was of interest. So I followed up, I believe I probably contacted the ministry, or anyway, to get hold of an application form. We had to fill in an application form. Which included references and other, had to put down why you thought you were qualified. Shortly after that, the ministry, they organized some evenings or some sessions for the public who'd applied, and you could come to probably, I think there's maybe 3 or 4 different evenings you could go to, where they would give you a little bit more information about what the trust fund is and what the board would be doing, general information. And then then we just had to wait, and we had follow-up information probably towards the end of 2016 and the start of 2017 through emails, and just telling us where they got to in the process and how they were selecting people. That was one of the emails that was sent out.
And so, and you can see, if you look at your bundle at page 12, section 13 provides that one of the way that the minister in appointing persons to the board, and these are the non-governmental appointees, there has to be public advertisement of the qualifications and other criteria required for eligibility.
That's correct, yes.
What happened? There was an advertisement for the post, is that right?
Yeah, so there's the advert which I saw and which I responded to. So anybody who'd applied, so first of all went to that public meeting and then had obviously submitted. And then at some stage there was an advert that said these are the following people who've applied. This is their this is the section that they'd applied for. Could be financial services, tourism, whichever section, and then a little bit about their background. I believe I can't totally recall exactly what was published.
I think if you turn to page 13, we see why that was done reflected in the Act, because if you can see the number 4 in brackets there, after the close of the application process, the Minister shall disclose to the public the names of all applicants and the sectors that they wish to represent on the Ministry's website. And so that the public were informed about what role the appointees were going to play. Is that right?
That's correct, yes.
So to summarize, just to make sure we've got it right, the possibility of applying was advertised.
Yes.
You applied using a form and references.
Yes.
You were invited to an open session where the role was explained to you.
Correct.
There were follow-up emails to tell you what progress was being made in terms of the appointment process.
Yes.
And then, as we've just seen, there was a public announcement of the appointees and what role, what part of, if you like, civil society they represented and what role they would play on the board.
Yes, that's all correct.
And in terms of the requirement for 6 members or 6 non-governmental appointees, as I put it, were all those positions filled?
They were, yes.
Now, if we
sorry, I should probably point out in the list of people on the board that includes the chief executive officer. That position wasn't filled because that position would have come later on. That would be the chief executive officer of the secretariat. So that position wasn't actually ever in place.
Because once the board was in place, part of your function was to establish your funds and set up your secretariat. Is that right? Correct.
Yes.
You would have then had to seek out and appoint a chief executive.
Correct. Yes.
Now, if you turn to page 14 in the bundle, we see at section 15 that the period of your term of office was for a period or stipulated to be a period not exceeding 3 years, but you would be then eligible for reappointment. So for you, your term would have expired in 2020, is that right?
Correct, yes.
What we see also at 15.2 is that the appointment of non-government members was intended to be staggered to ensure that no more than 2 non-government representatives are reappointed in any calendar year. So did you understand that to mean that you would not have a situation where all 6 non-government members would leave at the same time, but rather that there would be a change on a rolling basis?
That's correct, yes.
And did that happen in your case, in the case of your board, that there were people appointed at a later date than you?
Not at no, there was one person appointed at a later date. Yes, there was one of the board members was actually posted back to the UK, but their tenure was 1 year anyway. So that so rather than renewing it, that was allowed to lapse, and then there was a new person that came on the board going through the same process, and they were then duly appointed.
Now, under the Act, and I won't take you to the section unless you need to see it, but for the transcript, it's section 12.5. The board has a chair and a deputy chair. And were those appointments made?
They were, yes.
And what role did you take on, if any?
I was chairman.
And was that from the inception of the board, from the time that you came to be part of it?
It was, yes.
If we do, however, look at section 10 at page 10, this is a section of the Act which has the marginal status of the trust, and 10.1 says the trust is not a government fund of the territory, and the capital and revenue of the trust is not public money of the Virgin Islands, and as such not subject to control and accounting except as provided by this Act. And if we look at 3b, it also says that the trust cannot render the government of the Virgin Islands liable for any debts, liabilities or obligations of the trust. Keeping those in mind, what did you, as chair of the board, understand to be the relationship between the trust or between the board and government?
Maybe I can answer that by saying at the very start of the board's tenure, the very first job we had to do was to approve the operations manual. The operations manual was put together, was drafted by an expert in climate change and legislation. And it was made very clear to us that from an operations manual point of view and also from the Act's point of view, if the trust wanted to apply to international organizations to raise finance, the most important thing was the impartiality of the board and the trust and the independence of the same when it came round to what the trust is and what the board is, and then leave government to one side. So it was very clearly spelt out to us through that whole process that we were a statutory board and running independent of the government, if you like, although we had obviously government people on the board.
You mentioned funding, and let's look at page 8 of the bundle, please. Can you see the number 4 there in brackets, and in particularly 4A?
Yeah. Mm-hmm.
The trustee's duties was to raise funds from domestic and international sources. And under 7, we can see that the trust then had power to invest in various trust funds. And if you go to section 8 on the next page, at the very bottom there, 8.1 says that the trust could accept donations from lawful sources subject to such conditions as may be imposed by the donor, if doing so would not cause the trust to violate any provision of this Act. So given that you could raise funds, invest, and also receive donations, it does follow, doesn't it, that the intent, at least, was that the trust should not be entirely funded by government?
Oh, absolutely. There was obviously going to be some seed money, which came through a particular tax, but that would only be seed money and supporting some of the basics for running the trust. But yes, it was very clear that if you wanted for the trust to be successful, we would be applying to international bodies. There's one in particular we were told about, the Green Climate Fund. And if you wanted to apply to that, then you had to, the operations manual and the Act had to be drafted in a certain way to make you even eligible to apply.
You mentioned seed money. Can you just explain a little bit more about how that seed money was generated?
Yes, the government had separately instigated an environmental levy, which is charged to visitors on arrival, and it's $10 per head. And that was collected I can't remember which year it started. It was around about the same time as we were appointed, so maybe 2016. And those funds were collected and put into an account. They would be collected by the customs officers when people arrived into the BVI. The intention was that the Climate Change Trust Fund would receive 40% of those funds in order to give it annually a degree of seed money in order to run the secretariat and really to underpin the whole operation. During the time, from the time that we were appointed until December 2018, I think the issue was that the act that created the environmental levy and the climate change, the act that created the climate change fund, trust fund, they didn't talk to each other. So although there was mention within each about the levy and where it would go, it didn't actually direct that that's what would happen. So for all the time that we were a functioning board, a lot of our discussion was about how was that process going to happen and when was it going to happen. It was eventually decided by Cabinet, December 2018 again, I think was the date. They eventually decided where those funds would go, but I believe it then had to go to the House to be passed, and we never got to that point. So we never actually benefited from those funds.
And those funds were intended, as you say, to help you begin to establish your secretariat.
Correct.
And establish essentially a foundation for the next stage, which would be going out to seek further investment and contributions in order to do the work of the trust.
That's correct. It was fairly evident that in order to go out and raise or try and source funds, then you needed to engage with people that had access, and that would come at a cost. We were also, once we realized we were fairly close to receiving the funds, we also started the process of looking for somebody who could be qualified as a CEO, and also we were looking for a secretary to support them. So those are the areas that we were looking at towards the end of 2018.
And in terms of the reality of the trust board and how it operated, how often were you meeting as a board?
We were appointed just before Hurricane Irma. We did meet very shortly after Hurricane Irma passed. We carried on meeting. We had, I believe, from memory, a total of 15 board meetings between July 2017 and April 2019. So we were very much a functioning board. We were tasked initially, obviously, with the operations manual. That was a substantial document, and we had to be very familiar with it. The person that drafted it had a lot of knowledge, but very much wanted it to be our document. So we would sit as a board. We actually, outside of those board meetings, we then had training sessions over weekends, things like that, so that we were very familiar with the whole operations manual and the drafting of it. It's, as I say, a very substantial document, and that person that drafted it wanted it to be our document, not his document.
And was that person a consultant brought in from outside the Virgin Islands, or someone within the islands themselves?
No, he was brought in from outside, from Europe.
So he came in to help you essentially write your own operations manual?
Yes, he wasn't appointed by the board. He was already brought in by the government. So by the time we were appointed, the operations manual had been probably substantially drafted. And then it was our role then, to, as I say, to go through each section and make it into our document. How would it work for the BVI?
And again, please tell me if I've got this wrong, but as I've understood your evidence so far, the operation manuals was key to the next stage of the board's work, which would have been going out into the world market to secure funds for green initiatives within the Virgin Islands. Is that right?
That is correct. It was made very clear to us that we had various options in the way we could draft it. With the Green Climate Fund, for example, because the BVI is a dependent territory, overseas territory, it wouldn't in itself be eligible to apply directly to that fund to raise money. However, at some stage, we may be eligible to do that, in which case we had the choice: do we write the operations manual in this way, in which case we wouldn't be eligible ever, or do we write it in this way and make sure that at some stage we would be eligible? And we chose the latter. Again, we just didn't want to tie the board or the trust to an operations manual. Or you could always change it, but we didn't want to tie the operations manual to a format that couldn't stand up to scrutiny from an international organization.
Now, we've seen from looking at the Act a little earlier that as well as the non-government members, there were public officers who were part of the board. And you've explained why the Chief Executive Officer of the Trust was not actually a member of the board because he or she had not been appointed. But you had the Permanent Secretary and the Financial Secretary. Were those public officers attending your board meetings?
They were. They attended, if not all of them, virtually all of them.
And what was their role on the board?
The Permanent Secretary really was, as much as all of us, as I say, the focus was very much in the operations manual. So both the Permanent Secretary and the Financial Secretary were taking the same role as we were in giving input to that whole process. We did a logo, we did a website, so they had the same input on that. Where it probably differed was when it came to any discussion on the environmental levy, because as the private sector members of the board, we didn't have that connection with what was happening within government. So we then had to rely on their input much more as to that whole process of the environmental levy, at what stage it was within the process of being, the two acts being connected, and then finally the funds being allocated correctly to the trust fund. So they would take any information, any questions that we may have back to government, and then at the next board meeting would report back on where things have got to.
You spoke of some 15 board meetings starting sort of from July 2017. You were chair of the board. Do you consider that there was a good working relationship amongst the various members of the board?
Very good.
Non-government.
Yeah, very good. There was absolutely no how do I say, there was nothing that made the people from government any different from the people from the private sector. Everybody's working together, and it worked extremely well as a board.
And your last answer probably half deals with this question, but just so that we're clear, you were the chair. At any time, did those government officers raise with you any concerns over the way the board was operating?
No.
Did they raise any concerns about individual non-government members of the board?
No.
Can I ask you just to turn now to page 32 in the bundle? Do you have that page, Mr. Charles?
I have to, I'm scrolling down, yeah.
Thank you. Now,
okay.
At some point, and following the most recent election, the Climate Change Trust and the Climate Change Board moved from sitting under the Ministry of Labour and Natural Resources to the Premier's office. Is that right?
It did, yes.
I just want, before I ask you some questions, just to read out a letter that was sent to you from the Office of the Premier. The letter is addressed to you as Chairman of the Climate Change Trust Fund Board, and it's dated April 5th, 2019. It begins, "Dear Mr. Childs, as regards Climate Change Trust Fund Board, I write with regard to the above captioned subject. As you are aware, this administration has just taken office a little over 5 weeks ago. Since taking office, I have been assessing the functions and composition of the statutory boards across government, and more so, those boards that fall under the portfolio of the Premier's office. Further, you may be aware that a number of portfolios had been shifted around. Therefore, and in this regard, the climate change portfolio has been moved to the Premier's office. Thus, in keeping with our mandate, it is this government's intention to restructure the composition of membership on each board, inclusive of youth involvement on each board. A new policy attaching term limits on board membership to coincide with the term of the sitting government is now being implemented. Hence, in view of the foregone, we are seeking your cooperation in voluntarily tendering your resignation from the Climate Change Trust Fund Board by Thursday, April 11th, 2019. The government thanks you for your service rendered and wishes you success in your future endeavour." And it ends sincerely and is signed by Andrew Foy, Premier of the Territory of the Virgin Islands. Now, was that the first communication that you had received from the Premier's office following that election at which Mr. Foy became the Premier of the Virgin Islands?
Yes, it was.
Prior to that letter, had you had contact from any other minister in government?
No.
Had you had contact in relation to your position as chair and a member of the Climate Change Trust Fund Board from any public official?
No.
You'll see that there's reference in the letter to it being the government's intention to restructure the composition of membership on each board, inclusive of youth involvement on each board. What did you understand by the reference to the government's intention?
I suppose when I read the letter, it was government's policy to change boards, and I believe at the time there'd probably been information in the press indicating that there was the government were going to be was going to look at different statutory boards. I've got a memory of that, but I couldn't say where it would just be in the general press, I think.
Can you help the Commissioner with this? Was a letter in similar terms sent to all the non-government members of the Climate Change Trust Fund Board?
It was.
And so everyone was asked to voluntarily resign?
They were, yes.
Now, we'll come on to your response to this letter in a moment, but other than what I've read out to you, were you given any other explanation as to why you were being encouraged to voluntarily resign?
No, not at all.
I'm sorry to make you jump around in the bundle, but could you turn up page 14, please? Do you see there, we're going back to the Act, but do you see there section 16?
Yes, I do, yeah.
Section 16.1 that I want to draw your attention to, because that says that a member of the board can resign at any time by notice in writing addressed to the minister, and such resignation becomes effective upon receipt by the minister unless specified to take effect at a specified date. Now, we've seen the letter that was sent to you. Did any board member resign?
No.
Go now back to the last page in the bundle, and that's page 33. Now, this is a letter, and I'm going to read it out again, so it's on the record. But before I do, Between your receiving the letter which invited you to resign within a week from the Premier and sending the response we're going to look at in more detail back to him, were there any discussions amongst the 6 board members as to what steps you could take?
There were, yes. We spoke on the phone, and I believe we met. I'm pretty certain we met. At that stage, we decided it would be inappropriate to include the 2 government representatives. It would, I think they would be conflicted. So it was just the private sector members that discussed this. And we talked about the letters that we received. First of all, when I received my letter, I assumed it was just me that had it. So I did reach out to other board members, and that's when I realized everybody received the same letter. So our discussion was very much along the lines of what should we do? And I don't know if you want to read out the letter, or I can explain what our decision was. But we decided at the time, we were concerned that a lot of effort had gone into getting the trust fund to where it was at that point. In particular, we were concerned that the operations manual that had been agreed and approved was really the knowledge of all the people on the board. So individually, well, if any of us had to come off the board, it wouldn't really matter. But for all of us to come off the board at one stage, you were effectively starting again with the trust fund. And we felt that that would be an issue. We were also concerned that, again, this comes back to the ability of the trust fund to raise financing internationally. And what we were being asked to do was, obviously, we realized, we were familiar with the Act. One of the members of the board was actually a lawyer as well, so we had their opinion, if you like, and it was very clear that what we were being asked to do was not in agreement with the wording within the Act. So we decided to reach back to the Premier and request a meeting where we could explain what we'd been up to, where we were going, just give more information, and hope that we would have an audience where, and if at the end of the day the Premier wanted to change certain people on the board, the climate change trust fund is bigger than any individuals, but if I'd been asked to step down, I would have no issue with that at all. But I think we just felt that it was wrong for everybody to step down at the same time, and so we drafted this letter back requesting a meeting.
I'll read the letter in just a moment. Was the primary concern of the 6 non-government members that asking everybody to resign meant that collective expertise was going to be lost in one fell swoop?
Yes, I would say it's twofold. It was primarily that, but also it's setting a precedent that the whole point of the Climate Change Trust Fund and the Act, if you're going to be applying to these international bodies, is that there is a degree of independence, and this seemed to be crossing that line. So that was our other. So those were the 2 primary concerns.
Well, let me read the letter. It's a letter that you wrote and signed. It's dated the 17th of April 2019, and it reads as follows. Dear Honourable Foy, Virgin Islands Climate Change Trust Fund Board, I refer to your letter dated 5th April 2019, received by email on 9 April 2019, and I'm responding to you as Chairman of the Board, Virgin Islands Climate Change Trust Fund, and on behalf of the members of the board representing the non-government interests. We are delighted that you, as Premier of the Virgin Islands, have taken an active interest in the issues of climate change impacting the territory. We particularly noted your statement in March announcing that a statutory body would be established to develop plans, programs, and strategies for climate adaptation. The members of the board are a committed group and likewise passionate about climate change and addressing how to make the territory more resilient to anticipated climatic changes by introducing adaptation and mitigation measures to tackle the inevitable changes we will see in the years ahead. We are equally interested in ensuring the territory plays its part in reducing global carbon emissions while creating opportunities locally for businesses to invest in a renewable energy sector, which would be supported through training and. We have received your respective letters and would like to have the opportunity to meet with you to apprise you of the achievements of the board to date, which includes conveying the knowledge, training and continuity that has been established by the board since July 2017. We would like to see that our work will not be lost, and further, the ability for the territory to tackle climate change be delayed just at a time when progress is about to be made. And the letter, as we see, is copied to the following. John Klein, who was the deputy chair and the representative of the tourist sector. Ronnie Letsom, who was representative and an individual ordinarily resident in the BVI. Dr. Shannon Gore, as the representative of an NGO or community-based organisation. Dr. Catherine Smith, as a representative of the academic or research organisation. And Shelley Bend, as a representative of the financial services sector. So just so that we're clear again, this letter was not sent on your own behalf alone, was it, Mr. Charles? You were sending it on behalf of all 6 members who'd been asked to resign, is that right?
That is correct, yes.
And it's marked at the top by hand. Does that mean that it was physically delivered by hand to the Premier's office?
Yes, I delivered it myself.
Now again, you've said that the board had been working since July 2017. Before receiving your letter inviting you to resign, you had not had any communication from the Premier's office, and I take it from the Premier. But before Andrew Foy became the Premier, had he at any time from July 2017 approached the board to discuss its work?
Not to me, and I don't believe he approached anybody else, but I couldn't testify to that.
So 17th of April 2019, you wrote to the Premier. Did you receive a response to that letter?
No.
In any form of communication at all from anyone in government?
No, no communication at all.
What happened then? Did you resign?
No. The next thing we heard was, I believe it was minutes of a cabinet meeting that were made public, just advising that the Climate Change Trust Fund members had been taken off the board. I can't remember the exact wording, but that was the effect.
And that was all of you?
Correct, yes.
So other than that communication, a public communication of a decision of cabinet, was the decision to revoke your membership of the board otherwise communicated to you?
No.
Could you go, please, back to page 14 in your bundle? And if you look at section 16.2, please, Mr. Charles. Mm-hmm. We've looked at the resignation element of this provision, which was 16.1. 16.2 deals with the removal of members of the board, and it says as follows. This is 16.2. The minister may, with the approval of cabinet, revoke the appointment of a member of the board other than a government member if the minister is satisfied that the member A, is guilty of misconduct, B, failed to attend 4 consecutive meetings of the board of which the member had notice, except where leave was granted by the board or where the member is excused by the board for having been absent from those meetings, or C, knowingly failed to notify the board of a conflict of interest, D, no longer fulfills the conditions of appointment as set forth in section 12, or E, acts in a way that is detrimental to the trust. Now, you're speaking of yourself as an individual member. Were you informed of the reasons for the decision to revoke your membership of the Climate Change Trust Board?
No.
did your actions in any way come within any of the 5 reasons that are set out in the Act?
No.
And would allow a minister to remove a member of the board?
No.
As far as you are aware, did any of those reasons apply to any other members of the board?
Not as far as I'm aware, no.
And so does it come to this, Mr. Child, that you were never told the reason why your membership of the board had been revoked?
Correct, except for what was set out in the letter that was sent to me from the Premier's office.
And that was the letter inviting you to resign?
Yes. Mm-hmm.
Now, once all 6 members were revoked, that meant that the Climate Change Trust Fund Board just had 2 members on it, the 2 public officers. Do you know what has happened to the board since then?
No, I don't know what's happened to the board. I mean, there is an active current account with some funds in it. There's a stamp for the board. So yeah, but I have no knowledge of what's happened to the board itself.
Do you know whether there have been further appointments to the board as yet?
I don't.
The possibility, therefore, is that the board is inactive.
Yes.
Hasn't had new appointments.
Yes, I think I would have heard if there had been any new appointments.
Now, you spoke earlier of the concern not just by you, but by your fellow members of losing collective expertise. You started working in July 2017 as a board. You no longer worked as from April 2019. In terms of where the British Virgin Islands were compared to other Caribbean islands, were you at that time leading the field, so to speak, in terms of getting climate change financing and building a trust that would be effective for the Virgin Islands?
Yeah, in the process of, particularly when we were meeting with various experts in the field, the gentlemen that put together the operations manual and so on, they were able to tell us quite a bit about the background of the Act, where it fitted in, and I understand from them that this was the very first Act of this nature within the Caribbean that had been passed, and we would be the first board, obviously, to be working in this particular field where we could be raising money and investing it. There are other islands. Antigua, for example, was able, while we were still aboard, to raise a fairly substantial amount of money in the millions, and they were well established. And then since then, I've heard of other islands following suit and passing their relevant legislation. I don't know whether it's exactly the same as our board, but it was certainly in the climate change category.
Assuming that the board is still inactive because it hasn't had new appointments, something we can ask other witnesses to confirm. If that is the case, does that mean that in this area, the Virgin Islands may have lost ground compared to other jurisdictions?
Yes, yes. From there are certainly other islands that have advanced their climate change policy. And I've not seen, I saw something about a green paper to do with climate change management policy. I haven't seen anything further on that. So I've not, in the years that have passed since the board kind of was stopped, I've not really seen anything within the BVI advancing that.
You mentioned that there's still an active current account. As far as you're aware, is the environmental levy still in place?
Yes, yes.
So is the trust, the climate change trust, still entitled to 40% of that environmental levy?
I couldn't answer that question because I believe it was a cabinet decision in December 2018 that approved the funds going from the environmental levy to the trust fund, but I'm not sure. I think there was another step it had to go through, and I don't know. I couldn't say if that happened or not. So by the end of 2018, we had the approval, but I don't think we were quite there to receive.
But there are still, there is still an account with monies in it, just sitting.
I couldn't, I don't know.
I asked that because you mentioned an active current account.
No, we established our own current account. So the environmental levy money that's collected by government goes into a government account, nothing to do with us. We would then have received the funds, the 40% of the funds from that account. The account that we've got, the active current account that we have, is our own current account that we set up in order to start funding some of the things like the website and the logo and other things that we had to do. We also received some small donations, so those are still sitting in that account.
So just so clear, you said it's an account we set up. So were members of the board contributing their own funds to try and get things going?
Yes.
Thank you. Commissioner, if I could just have a moment.
Certainly,
please.
yes.
Commissioner, those are all my questions. So can I conclude, first of all, by thanking Mr. Charles for making himself available to give evidence to the Commission today, but also thanking him for the assistance that he's given in the way he's given his evidence. Thank you.
Yes, can I echo that, Mr. Charles? Thank you very much for thank you very much for giving your time and giving the assistance that you have. It's very much appreciated. Thank you.
Thank you very much, Commissioner.
Commissioner, may I ask for permission to ask Mr. Charles some questions coming out of what he has said?
Well, under our rules, no, but you can ask Mr. Rawat. What I suggest is that that's done separately.
Yes, perhaps if I'm sorry, it will keep Mr. Charles a little bit longer, but if we rise perhaps for 5 minutes, and I could just try and have a conversation with Mr. Hirey by different means, so we can see how we do it.
That's the way to do it, Mr. Hirey. Mr. Charles, could you just hold on to this line for now? I'll rise for a few minutes. Mr. Hirey will speak to Mr. Rawat. If there are any more questions, then we can put them to you before you go. Thank you very much.
Thank you.
Thank you.
Yes, Mr. Charles, you're still there. You can still see and hear us.
I can indeed, yes, thank you.
Mr. Wright.
Commissioner, if I could just say, I'm grateful for Mr. Hyrie and I did find a means of communication, which is that he's emailed those questions, and I've had an opportunity to look at them. There are just 2 questions, and I'm happy to put them to Mr. Charles in the form that they have been drafted. Mr. Charles, there are 2 more questions for you. The first is this: did the board raise any material funds from its establishment in July 2017 to February 2019?
Just one moment, Mr. Charles. Just to what I recollect of the evidence that you've given is that you said that until I think it was December 2018, when I think a cabinet decision was taken, there was a sort of hiatus in your obtaining the money from the levy, because I think, as you put it, these 2 organisations didn't sort of communicate very well. And you needed the levy money, which I think you referred to as seed money, to be able to go on and do other things, like set up the secretariat and go and get other money. That may not entirely answer the question, but it may go some way to answering the question. But you have the question, Mr. Childs.
Sure. So the question is, did the trust fund board raise any substantial monies? The answer is no. What we did, we went to talk to some people who are active in climate change and are the people that would go out on your behalf to go out and raise the money. But in order to engage with them, there would be a substantial fee in order to build up. You have to build up a business plan and everything else. And you're talking probably several tens of thousands, if not hundreds of thousands of dollars to engage with those kinds of people. So it wasn't something that we were in a position to be able to do at any stage.
And can I just follow up on that, Mr. Charles? And it's just to clarify what was put to you by the Commissioner. Mm-hmm. What you needed was access to the environmental levy funds in order to take the trust onto the next stage. Is that right?
That is correct. So that's really the way everything was set up. That the trust fund would receive the 40% of the funds raised by the levy in order to start establishing the secretariat, bring on the CEO, whose job would then be, that person would then be the person to go out and actually raise the funds and get everything going under the Trust Fund Act.
And you mentioned in your evidence the operating manual, which is obviously an important tool. And what did the operating manual go to? What was its scope? What did it assist?
It covered everything. Yeah. So that the operations manual would literally the way the entire fund would operate, the way the board would operate, the way the secretariat would operate. So going, lots of different sections. And because it was going out to the international community, so one of the choices I think I mentioned we could either go this route or this route, and the route we chose to go was the international route within the operations manual. So it would cover lots of things like fair business practices, no discrimination. So you'd have lots of different sections dealing with those types of issue, which wasn't necessarily to do with the running of the board or the secretariat. It was just good business practice, and we chose to incorporate those. So the operating manual really covered everything. It
covered as it were, the process of going out and getting international money.
Very much so. The process, going out to get the money. Once you've got it, how do you then deal with the money? How could you spend it? How could you invest it? What organizations could you invest in? And there were restrictions, obviously, on some of that. And then the practical side of it was how you would then, or how the secretariat would then go out to the public to invite the public to apply for for funds. So a member of the public could say, look, I want to set up this solar panel business and come to us, or the trust fund could say, or the board could make a decision for the following year on what it was going to concentrate on. Maybe this year we'd concentrate on building resilience in buildings or something like that. And so you'd have a program that you'd establish, and then people apply to specific programs. So it was just setting out the roadmap for everything from all areas of the operation. It was a very extensive manual.
So it included getting the money in and how the money went.
Exactly, yes. Yeah.
That detail is very helpful, thank you.
Before I ask Mr. Hyries' second question, can I just ask a question in relation to the manual? You said that you had the assistance of an external consultant.
Mm-hmm.
How long was that individual working with you as a board for?
So how long?
How long did that person work with you?
So he was already appointed by the government's climate change body. So that was a body within the government organization. So he was already engaged by the government. And then, I think he was I can't remember the exact where the funds came from, but I think it might have been through the Caribbean Fund or something like that. Can't remember the detail. So he was paid for, so he was on board before we were appointed and established as a board. So by the time we came on board, the operations manual was substantively complete. And as I said in my evidence, it was up to us to then agree what elements were going to be relevant to us as a board and as the BVI Climate Change Trust Fund. So he was working with us from the moment we were appointed. We had Zoom sessions with him. He was working remotely. So we would, he would introduce us initially to what the scope of the operations manual was intended to do. So we had those sessions, and then we went through individual sessions on the different elements of the manual as we went along. How long did that take? It was quite a long time. I think we were probably working that for the better part of a year, I would say. I should think by summer 2018, we were substantially through it and had completed the operations manual.
The second question that I'm asked to put to you is this. Aside from the manual, what did the board achieve over its 15 meetings?
Right, so we were establishing how once the funds was ready and we were able to go, we wanted to be ready to go and not then starting to think about what we're going to be doing. So we were preparing the business plan. So we would, under the operations manual, we'd have a short-term plan and a 5-year plan. So what are we going to do over the next year? We were doing the RFPs for the CEO and a secretary, because that's what we felt that we would need to start off with. We had a basic website and we had logo design. We approached different bodies who could represent the Climate Change Trust Fund in approaching international monetary organizations. So I was on calls with sort of 3 or 4 different organizations to really get that ball rolling. And that would be inviting them to give us proposals. Yeah, so and yes, I mean, it was a lot of different things. I would say, I mean, towards the end of that period, we were starting to get a bit frustrated that the momentum, to get the environmental levy funds over to the Climate Change Trust Fund, it was just taking a long time. I think we were expecting that to be in place by probably the summer of 2018. So we were aiming to be, we had in place press launches and so on. And then it was fairly evident that that wasn't going to happen for various internal government reasons. So, and then, as I say, we didn't actually get to that point until the end of 2018. So there was, we had to keep on rolling the ball down the line, waiting for that. From my point of view as chairman, my position was I didn't want to be going out to actually launching RFPs for a CEO or whatever until we knew that we could pay them. There was no point in jumping the gun, going through that process, interviewing, asking people to interview, possibly even come to the BVI for interview, and then turning around saying, well, actually, I'm sorry, but we're not ready to go. There'd be no point in going down that route at all.
Could you just clarify for us, what does RFPs stand for?
Sorry, request for proposal. So we had RFPs going out to, we would have been going out to different people, as well as job descriptions and advertising for the CEO position, the secretariat, the secretary position. RFPs, to people who could be advising the fund on. So we had the initial discussions, but we never actually went and said, okay, go ahead and do it.
Thank you very much, Mr. Charles. I think those are all the questions we do have for you.
Yes, thank you, Mr. Charles. Thank you for your assistance this afternoon. Thank you very much.
Okay, thank you very much. Bye.
Commissioner, we can let Mr. Charles go now, but there is just one matter that I wanted to bring to your attention on which we may be able to be assisted by Mr. Hirey. And that is that you may remember, Commissioner, that and you will remember, on the 30th of August of this year, we wrote to the Attorney Generals raising a number of requests which relate around criticisms that may be made of others. And those are to be communicated to the COI by today, 4 p.m. But they included mention that was made by Sir Geoffrey Cox QC at a hearing on the 13th of May, that the attorney considered that in looking at matters under inquiry in the COI, she was going to seek out wrongdoing and bring it to the Commissioner's attention. And Sir Geoffrey explained that those were his clear instructions. The letter asked that the attorney or the IRU team set out what they have found as a part of that process, and whether there was or may have been evidence of wrongdoing. I just wanted to draw it to your attention. You may want to ask Mr. Hirey whether what the present stage of progress is in relation to that response.
It's a good point, Mr. Wright. Mr. Hirey, you'll recall the letter. The letter makes one request simply for a schedule of criticisms which those the Attorney General represents wish to make, but including the wrongdoing that the attorney was seeking out, according to Sir Geoffrey, and also the evidence given by the Premier when he gave evidence that the previous administration was corrupt. Now that I think is due 4 o'clock today. Yeah, 4 o'clock today, that's due. We've had no suggestion that you need an extension of time. So are we right to presume that that is going to come in the next half hour?
Yes, you're right to presume that a letter would come, and we will try and have it in the next half an hour, requesting an extension of time, not very long. In terms of the criticisms, they are essentially those set out in the Minister's statement, and also the Minister's responsive statement, both of which, of course, the COI team has. But the extension of time is to provide for some scheduling in the way that the COI has asked us to do. So that will be with you very shortly, sir.
Is that coming in today, Mr. Hirey? Just forget about 4 o'clock at the moment, but
yes, yeah, the letter requesting the short extension will come in today. Yes.
But the letter requesting the extension will come in today.
Yes, the letter requesting the short extension, so as to set out the various issues in the tabular form that the COI has requested, would come later this week, subject to you approving the extension.
Yes, I mean, but because we're now entering this phase of the hearings, it's obviously very important that we have any criticisms that the elected ministers are going to make.
So what I can assure you is that there aren't any criticisms that are not already in the minister's submission or in the minister's response to the governor's statement. So those two documents the COI has had and has had for some time. So there won't be anything new. It shouldn't be, I don't think, in that sense, difficult for the COI to work with them. But if it's required in the format that is sought, we will provide it in that format. It'll just take us a little longer.
That's helpful insofar as it goes. And presumably the letter that you're going to send us is going to cover the two matters that we raised, that I raised in the letter.
It will.
Excellent. Okay.
Thank you very much. Thank you, Mr. Hyrie.
Yes, thank you, Mr. Hyrie.
That concludes our business for today. We are due with our first witness tomorrow at 10 o'clock.
Yes. Thank you all. 10 o'clock tomorrow. Thank you.
Thank you.